Hi, everyone. We're waiting for everyone to come in. We will start shortly.
Hello, this is Amy from China.
Hi, Amy. Thank you for joining us. We're going to get started in a few minutes.
Thank you. I'm looking forward.
Hi, everyone. We'll go ahead and get started. So, hi, my name is Justin Lee. I'm the Senior Business Editor of Santa Clara's Journal of International Law. We wanted to welcome everyone to our annual symposium. This year, our topic is on China and the reshaping of international order, legal order. We have an incredible lineup of speakers today with attorneys specializing in IP, trade, and human rights, who will be speaking over our three panels that will be moderated by great professors at Santa Clara Law and the University of Oregon School of Law. And now I'll turn it over to our managing editors, Diane and Michelle, to go over the event logistics.
Thank you so much, Justin. My name is Diane Giacotti, and I'm one of the managing editors of the Santa Clara Journal of International Law. I want to thank you all for joining us today and take a moment to recognize the special nature of our virtual symposium. We are honored to be accommodating a significant turnout of attendees, and we would like to acknowledge all those who are joining us from all around the world today, including Beijing, Hong Kong, Tokyo, Notre Dame, New York City, Eugene, and the Bay Area. You may already be familiar with some of Zoom's webinar functions, but we would like to remind everyone of some of these features and general house rules. Please note that all attendees will not have access to video and microphone capabilities. However, we want to encourage you to send any questions you may have for our panelists in the Q&A function, which you can find located at the bottom of this window. Please know that we are recording this event, and if you run into any technical issues at all, you may contact Justin directly via his email address noted on the website. I will now turn it over to Michelle.
Thank you, Diane. Hi, everyone. My name is Michelle Trung, and I'm one of the managing editors of the Santa Clara Journal of International Law. We're really excited to have you with us today and are very pleased to be offering MCLE credits to all California attorneys in attendance. I will take a brief moment to explain the process. If you are interested in receiving MCLE credit, please fill out the Google form we will send in the chat box. Given the nature of our symposium and how it'll be remote, at the start of every panel, we will be sending a Google form in the chat, and you only have to fill out the Google form once. Please indicate on the form which panels you will attend. At the end of every panel, you can expect to receive the MCLE evaluation and certification forms for each panel by email. Please fill out the forms and return them to the email address which you will be receiving them from, and we will keep them for our records to note your MCLE credit. Once again, we will be providing a Google form in the chat box for you to fill out to begin the process of receiving MCLE credit. With that, we're so excited to begin this event. I'd like to now introduce Dean Michael Kaufman, who has a special message for us.
Good afternoon, everyone. Good afternoon. My name is Michael Kaufman, and I have the honor of serving as the 16th Dean in the 110-year history of Santa Clara University School of Law. On behalf of my faculty colleagues who are joining us here today, on behalf of our students who put this incredible program together, on behalf of our alumni who give so generously for our students and for our community, on behalf of our entire university, it's my great honor and privilege to welcome you to a very special moment, a special occasion in the life of our law school community over the course of the year. The program today is entitled China and the Reshaping of the International Legal Order. It is, of course, put on by our wonderful Santa Clara Journal of International Law. And we have a tradition here, as you may know, at Santa Clara. We begin every special occasion with an expression of gratitude. This truly is a special occasion, so allow me to begin with an expression of gratitude. I want to first each and every one of you for joining us remotely from across the world for today's program. It's wonderful to have you here, even by remote means. Thank you for coming. I want to thank especially as well all of our speakers, our experts, our panelists, our moderators, and my faculty colleagues as well who have joined us to lend their expertise and their insights to an incredibly important topic. I want to thank as well our student editors, our managers of this incredible endeavor who worked so hard to bring us together today for this very important program. You know, as we talk about China and the International Legal Order, I think it's incredibly powerful that our student editors have selected 3 topics to address our attention today. The first, of course, is enforcement of intellectual property. Number 2 is international trade and cross-border regulation. And finally, number 3, human rights. And what's so impressive about those 3 topics is this. Each one of them, my friends, is a distinctive strength of Santa Clara University School of Law. We are incredibly well-versed here at Santa Clara in Silicon Valley about intellectual property and high-tech law. We're really good at that. We also have a great distinctive strength, of course, in international relationships and global relations as well. And finally, because it's Santa Clara, true to our Jesuit mission, our heritage, we are focused intently on human rights. So the confluence of those 3 issues today, intellectual property, high-tech law, international relationships and global relations, and human rights is so true to Santa Clara's mission and its distinctive strengths and our enduring values. So you have a conference ahead of you today, but it's not just a conference about China and the new international legal order, but one distinctively Santa Clara at the core of our mission and our values. I could not be more grateful, therefore, to welcome you to this incredible day put together by our students and our expert panelists and speakers. I know we're in for a treat, and I welcome you to this journey. Have a wonderful day and a very thought-provoking one at that. The very best of luck throughout the day. And I hope you really get tremendous value out of it. I know you will. Thanks so much.
Thank you so much, Dean Kaufman, for your encouraging and kind words. Now I'd like to introduce our first panel of the day, the Enforcement of Intellectual Property, moderated by Professor Eric Priest from the University of Oregon School of Law. Professor Priest specializes in intellectual property law, focusing on copyright law in the information age and creative industry ecosystems in the US and China. Please welcome Professor Priest.
Thank you very much, Michelle. I trust everyone can hear me okay. So it is my great honor and pleasure to be part of this symposium. Thank you so much to Michelle and Daniel and all the other folks working hard to make this symposium happen. I actually am kind of a last minute stand-in for Mark Cohen, and anyone who is participating in this symposium who works in China IP issues is probably familiar with Mark. And Mark unfortunately had to bow out of this at the last minute for personal reasons. And I do not propose at all that I will be able to fill Mark's shoes. Mark is, in my view, the Dean of Intellectual Property, China Intellectual Property Studies in the United States. His knowledge on the subject is vast, and I can't hope to match it. But I will do my best to facilitate this discussion, which I think is going to be enlightening and fascinating because Chinese intellectual property, I mean, it might seem to some a little bit odd to start a symposium on China's sort of emerging role and effect on the world order with a discussion of something that might seem a bit like a legal backwater or maybe inside baseball by talking about intellectual property, but try to name a presidential or identify a presidential debate, for example, in the past 2 decades in which there hasn't been a discussion of, China is stealing our technology. What are you going to do about China and its theft of American innovation, et cetera? These are sort of the kinds of this is the kind of rhetoric we hear all the time in the U.S. And certainly globally. But of course, the reality is complex. It's nuanced. But there's no question that when we talk about trade, when we talk about the evolving global economic order, intellectual property is an incredibly important aspect of that. It's an incredibly and increasingly important aspect of China's economic development plans, of China's actual economic development, and therefore it makes sense to, I think, when we talk about China as China's emerging role globally, to take a good hard look at the role that intellectual property law and policy plays, and also because intellectual property is so important to international agreements, to treaties, to both multilateral and bilateral relationships, trade relationships, the WTO. So hopefully we will be able to touch on facets of all of these aspects of intellectual property in China's development and China's the future of China's role in the world order. So on our very distinguished panel, we have 3 experienced intellectual property practitioners with, again, with vast experience in Chinese IP. So we have David Tsai, who is an IP litigation partner at Pillsbury, Winthrop, Shaw, and Pittman in the San Francisco office. And David also co-manages the firm's office in Taipei. Then we have Amy Wang, who is the senior attorney and litigation team lead at Intel China. So we will hear about from Amy about developments in patent law and technology and intellectual property. And then we have Benjamin Chiu. And Benjamin is a partner at Loeb and Loeb in Hong Kong and specializes in a number of facets of intellectual property, including portfolio building, licensing, and IP protection and enforcement. I will just refer you to their bios on the website if you would like more detailed information. But otherwise, I would like to just jump into our discussion. So let's start with David, who's going to talk about China's domestic IP strategy broadly.
Thank you, Eric, for the kind introduction. It's nice to be here with everybody. I'm going to talk basically based on some of my experience and what I've seen and what I've read about with what's happening in China, because I haven't been in China since 2019, the end of 2019. There's been a lot of change. I know for a lot of our clients based in the US or even Asia, we saw that initially China's government and various entities of the government were subsidizing patent prosecution and encouraging companies or individuals to patent as much as they can. And oftentimes you saw more patents than you needed for a single invention, where really there was really just one invention, should have been one patent, and there were 10 patents around the same invention. And so there was this whole burst of patent filings, not just in China for Chinese companies, but throughout the world. And at one point, I think in 2019, there was a statistic in 2019 where China accounted for the world's total filings of utility patents, about 96.9%. I don't know if that's true, but I know overall they said that it was about 43.4%, which is pretty significant. And it could be 96.9 if there were lots and lots of patents filed in China, and the Chinese Patent Office issued a lot of those patents early on. The Chinese government has changed its attitude, though, with respect to these patent filings, and more recently has implemented some reform around that. There's in January 27, 2021, there's a China National Intellectual Property Administration issued the circular on further strictly regulating patent applications and making sure that there weren't multiple applications being filed for the same invention. And in China, there's three types of patents. There's a utility patent, which we usually, we call a lot of our patents in the US utility patents, but they have a utility patent, then they have an invention patent, and then they have a design patent. A utility patent is usually just an improvement on some sort of invention. So really it's the invention patent that's equivalent to what we have in the United States. We don't really have a utility patent in the United States. And the utility patent, I believe, in China has a much shorter enforcement period where you could enforce that patent. And design patents obviously are very similar to those here in the US. But in the past, when China was encouraging the filing of patents, you would see a lot of utility patents that cover the same exact thing as the invention patents, or vice versa, because they got the utility patent first. And so I think China's government is trying to reform that, so there really is just one patent around all that. I think also in terms of changes, there obviously is now an IP court in China, similar to sort of, I mean, it's not, we don't have an IP court here in the United States because really every district court can hear an IP case, but we do have the Federal Circuit, which does hear a lot of patent cases on appeal. So that could be sort of an IP court. But there are many countries in Asia and Europe that have instituted these IP courts, and China created one themselves, and that was established in January of 2019. I was just looking at some of the statistics around that. It looks like just 2021, there were 437 cases heard there at the IP court. But IP cases are still heard throughout China. And of course, Shenzhen has a lot of companies. So the cases in Shenzhen have increased significantly since 2019. But by far, the most popular court is still Guangdong, and that could be because of favorable judgments there. But companies are finding ways, especially foreign companies are finding ways to have those cases transferred to so-called more favorable venues where they are located, such as the Shanghai courts. In terms of, I'm just talking about generally what's happening in terms of enforcement actions in China. Those still are small value compared to the US. There's no multi-billion US dollar judgments in China. They're quite small still, but the reform that I was talking about earlier, China has reformed some of their damages so that there could be, if you're found intentionally infringing, you can owe up to 5 times the amount for willful infringement, unlike the US where it was just trouble. And in addition to that, they have increased the statutory limits or minimums, I guess, of damages up to 600,000 renminbi, or I think it's 600,000, or is it? I believe it is. Or 500,000 renminbi. So it's pretty significant. It's around 200,000 US dollars. I guess it's not a lot of money here, but in China, that's pretty significant. But again, the damages are very small. So what you usually see in China when there's enforcement actions by a Chinese company or by a US company or any foreign company is that they're looking for an injunction against the factory that's manufacturing the infringing components. But the issue around that is sometimes you get a judgment in Guangdong, and then the infringing company moves that factory to Shenzhen, and then you need to get another order. Sometimes that happens. So those are some of the issues. But foreign companies in China have been successful in obtaining monetary damages, but at the same time, they've also found issues with their patents. And like there was a case recently in 2020 where Wabatso, a German automobile manufacturer, had its Chinese patents invalidated. So that can happen still. So that was just my brief overview. I know we're going to talk about SCPs too, and that's an important issue, I think, globally, because there was a Chinese court that had a decision where SCPs are SCP organizations, where organizations have standard essential patents, can have their royalty rate decided in China, even if the Chinese patents are a small part of the portfolio. And that could cause a lot of incongruity across the world in terms of determining royalty rates. So that'll be interesting. I think Amy might touch upon that a little later, but that's just a brief introduction of some of the issues and that we could talk about later about just the issuance of patents and enforcement actions and how they are being handled in China right now.
Great. Thank you, Dave. Yes, and I do believe Amy does plan to address that in the standard essential patents and the role that national courts and Chinese courts are playing in setting the licensing rates for those. So we will get to that when we have Amy on deck. But first, I believe we are turning to Ben, and I would like to thank both Ben and Amy because if my calculation is correct, I think it's about 4:30 in the morning where you are. Ben is in Hong Kong and Amy is in Beijing. Is that right? So I know that historically the Yongzheng Emperor was said to be up and working at this time, but I certainly am not normally, so especially on a Saturday morning. So we're very grateful for you being willing to do that. Ben would like to tell us about well, a number of aspects of Chinese IP, including licensing. So, Ben.
Thank you, Professor Priest, and also thank you for the organizer of this symposium. Yeah, it is early hours, but after this panel, it's probably time for breakfast here. I guess when people think about what happened when it comes to Chinese companies, especially inventive Chinese companies, and their relationship with IP over the recent years, bear in mind that China has come a long way when it comes to establishing a domestic IP legal framework. China had absolutely zero copyright law until 1990. The copyright law only came into effect that recent, barely 30 years ago. And until early 80s, there was also absolutely no patent or trademark protection. Of course, there were some industrial policies at that time, but a lot of what's happening over the past 30 to 40 years with respect to IP law in China had a lot to do with international trade. In the 80s and 90s, the Western world, while led by America, really pushed developing countries, including China, to adopt these international norms to protect IP. And the lure is for this country to participate in trade, leading to 2001, when China became a member of the World Trade Organization, WTO, and the rest is history. So a lot of what we see when it comes to international IP enforcement, litigation, lawsuits, and now we are coming to a point where we see more Chinese company gradually becoming international IP licensing powerhouse. It's really a natural progression of international trade policies, how China participated in the global supply chain, global manufacturing, and the development of a number of industries. It used to be a lot of litigation and also licensing in 3G or 4G technology, if we use telecom as one of the major examples. And gradually we see more licensing deals and litigation when it comes to 5G patents. So we see a lot of these things as more Chinese companies participate in these new industries. And along with telecom, there are other new industries coming up. I have some brief slides that highlight some of this. Let me see. So as David just pointed out, there's been a huge jump of the number of patents filed by Chinese companies. You see that domestically, the number has really increased over the past 10 to 12 years. When it comes to international numbers, the increase has been more or less on par with America and Europe. But of course, the domestic market in China became increasingly important. A lot of international companies have been active in China. They have sued Chinese companies for patent infringement and other IP infringements. But bear in mind that as more Chinese companies becomes more sophisticated, they actually tend to sue other Chinese companies, both in China and also internationally. So, and these industries oftentimes are increasingly emerging industries, such as electric vehicles, autonomous vehicles, batteries, car batteries, charging stations, artificial intelligence, digital currency. For example, it's been reported that the central bank of China itself has filed more than 100 patents, mostly relating to digital currency. And there are some more traditional industries in telecommunication, manufacturing process, life science. Those have also been increasing. Bear in mind that technology licensing is not the same as patent licensing. A patent license is simply a promise of the patent owner, the assignee, to a promise not to sue you if you do this and that. Technology licensing oftentimes is some sort of enabler to allow a company or individual to practice some technology, not just based on what's disclosed in patents, but also trade secrets, sometimes a very vague know-how. The licensing package may include a promise to send my people to come over and teach you over a number of years for you to build your plan to participate in certain trade. Sometimes it could be a very wholesome, what they call a turnkey solution for enabling a company to do certain things. And so with the importance of patents and other IP assets, China had a national strategy back in 2008 to become a major player in international technology licensing and IP protection. And the number of patents has shown some of the force for Chinese company to really excel and participate. That doesn't necessarily mean that all the patents are equal. Most of the patents that has been filed in China over the recent years are not necessarily of high value or active patents, according to some ways to describe it. We can say that active patent typically means a patent that has been involved in litigation or licensing agreements. America still has a lot more patents like that. But having said that, numbers does matter. If a company has a small patent portfolio of, let's say 2 to 3 patents, even if those are high quality patents, it may not be enough to establish a portfolio that grabs attention from their competitors. If a company has dozens of patents, just to use attorney time to analyze those patents could be prohibitive. Thereby, it may make sense for the competitors to considering licensing the platform, maybe along with other IP assets, but numbers does matter. And in recent years, there's some sort of a geopolitical decoupling happening between America and China. And it happens on both sides. In part of China being nervous with potentially being choked off of semiconductors, for example. China has encouraged a lot of domestic investments and R&D in semiconductors. But doing that doesn't necessarily mean it could be a quick fix that China will overnight have a semiconductor industry on par with the US. But it does encourage a lot of investment activities and R&Ds and also patent filings. And this kind of international norm has been very beneficial for Chinese companies. A lot of people in manufacturing, especially when it comes to electronics, have heard about the term FRAND, which stands for Fair and Non-Discriminatory Patent Licensing Terms. there's been a joke that a friend is maybe the best friends of the Chinese companies, especially the electronics manufacturers, which means you can license a whole portfolio on reasonable terms without worrying too much about being sued from multiple holders, especially multiple holders who have the SEPs, the standard essential patents. So I've covered quite a bit about the licensing and how a lot of Chinese companies got here. I'll maybe wait for the additional comments from other panelists and get to the Q&A when we discuss more.
Wonderful. Thank you, Ben. So I think that's a terrific transition point for Amy talking about the international friend and the complexities of standards essential patent licensing in the international marketplace. China is obviously a major market for all kinds of consumer goods, including technologies that are subject to standard essential or that incorporate standard essential patents. And so we are very privileged to have Amy here to discuss this topic in more detail.
Yeah, thank you, Professor. And also thanks Santa Clara University for inviting me to speak at this IP panel of this symposium. So I would like to present a few slides. Okay, maybe let me. So Ben, could you please stop your sharing?
Oh, I see. Okay, sorry.
No problem.
There we go.
Okay, thank you. So could you see my screen? Okay. So by today's opportunity, I would like to share a brief overview of the anti-suit injunctions in SEP litigation in China through analyzing its legal basis and the factors considered by the Chinese courts in granting anti-suit injunctions. Introducing a couple of typical cases in China involving anti-suit injunctions and sharing the different views from the courts and legal experts on this particular issue in China. First, I think because probably some of you may not be familiar with the concepts of SEP, French, anti-suit injunction, and other particular IP terms that I will cover today. So let me give you a brief introduction on them. SEP means standard essential patent, which word you may have heard frequently in the telecom industry, as more and more telecom manufacturers are deeply involved in the development, setting process, and protection of technical standards. French, as Ben just introduced, it means that fair, reasonable, and non-discriminatory, which is a commitment aiming to avoid and reduce the monopoly pricing by SEP holders. Today, I also would like to focus on the introduction on for anti-suit injunction, which means an order from the court to the party not to pursue or not to commence court proceedings abroad, which is historically known in the transnational litigation dating back to 15th century England, and now is widely applied in the global SEP litigation. So next, after understanding the basic concepts, let's move to an interesting phenomenon in SEP litigation in China. That is why the anti-suit injunctions surged. Anti-suit injunctions surged in SEP litigation in China since 2020. Although the Chinese leading telecom company like Huawei was involved in global SEP litigation back and became the target of anti-suit injunctions issued by the foreign courts back to more than 10 years ago. I think the first reason is the rapid development of the entire Chinese telecom industry, including the emergence of the multiple leading companies like Huawei, ZTE, Xiaomi, Oppo, etc. And most of them, they are deeply involved in the global SEP litigation in the recent years. So they began to consider taking multiple measures to protect their interests in litigation, including convincing the Chinese courts to issue anti-suit injunctions. The second reason is that as many telecom manufacturers in China became the targets of the anti-suit injunctions granted by the courts in US or in UK in SEP litigation, they need to consider anti-suit injunctions issued by the Chinese courts as a kind of countermeasures to pursue their better interest in the global patent campaign. The last but not least reason is the courts in UK began to determine French global rates since 2020, which triggered the Chinese court's intention to set China as the jurisdiction of choice for global disputes, and the insurance of anti-suit injunctions could help Chinese courts to prevent the review of SEP litigation in other jurisdictions. The legal basis to support the Chinese courts to grant anti-suit injunctions in SEP litigation is Article 100 of China Civil Procedure Law, which allows the Chinese courts to make a ruling to prohibit one party in suit from committing certain acts. So anti-suit injunction in China is regarded as a kind of act preservation. As I will introduce, as I will introduce later, the first anti-suit injunctions issued by a Chinese court in SEP litigation is in Huawei versus Convincent case, where the Supreme People's Court defined a couple of factors for the Chinese courts to consider when granting an anti-suit injunction in SEP litigation in China. The first factor is the impact of foreign litigation on actions pending before Chinese courts. The Supreme People's Court held that in determining whether to grant an anti-suit injunction, the court should first examine whether the enforcement of a foreign court decision would have a substantial effect on the trial, adjudication, and the enforcement of the parallel proceedings in China. The court may issue an anti-suit injunction if it finds that the respondent's relevant behavior might hinder the trial of the parallel litigation in China or make it difficult to enforce the relevant Chinese judgments. The second factor is to consider the necessity of granting an anti-suit injunction. The Supreme People's Court held that the examination of the necessity of granting an anti-suit injunction should focus on whether there would be any irreparable harm to be suffered by the applicant or difficulty in enforcing Chinese court decision in the absence of an anti-suit injunction. In principle, a Chinese court could issue an anti-suit injunction only when it is truly necessary. The third factor is the balance of the interest between the two parties in suit. The Supreme People's Court held that in determining whether to grant anti-suit injunction, the court should also consider the balance of the interests of both parties and weigh the harms the applicant might suffer in the absence of an anti-suit injunction and the harms the respondent might suffer as a result of an anti-suit injunction. The first factor is the impacts on public interests, which requires the Chinese courts to consider whether the public interest would be harmed by the injunction. The last but not least factor is the principle of international comity. In this regard, the Supreme People's Court held that the following specific factors should be examined. The first one is the temporal order by which the action in China and the actions in other jurisdictions were filed. And second is whether the courts have the appropriate jurisdiction and whether the impact on anti-suit injunction would have on the trial and the adjudication of foreign cases is proportionate. So in the last 2 years, there were totally 4 typical SEP cases in China, in which the Chinese courts granted anti-suit injunctions. In the next few slides, I would like to give you a brief introduction of these cases, through which you may have a better understanding regarding the intention of the Chinese courts to set China as a jurisdiction of choices for global SEP disputes. The first typical case was the SEP dispute between Huawei and the Conversant, in which the Supreme People's Court issued the first anti-suit injunction in the SEP litigation in China, and also provided guidance to the lower courts facing similar issues. In parallel with the German action brought by Conversant, Huawei applied to the Supreme People's Court in China in 2020, seeking an anti-suit injunction to prevent Conversant from enforcing the German injunction order until the conclusion of the Chinese dispute. In the decision made by the Supreme People's Court in China, the court elaborated the relevant factors that a Chinese court should consider when granting an anti-suit injunction, as I introduced earlier, and also provided the specific analysis regarding the connection between these factors and this particular case. The Supreme People's Court started its analysis that the parties in the German judgment and the Chinese case were basically the same, and the subject matter of the disputes partly overlapped. Furthermore, enforcement of the German injunction would interfere with the Chinese litigation, producing a negative impact on the Chinese trial's progress or enforcement of the outcome. Regarding the impacts on the parties in suit caused by the anti-suit injunction order, the Supreme People's Court held that the insurance of an anti-suit injunction was considered necessary because the irreparable damage that Huawei would suffer from withdrawing from the German market or accepting a Conversant license offer, which was much higher than the French rate set in China. On the contrary, with regard to the balance of the interest factor, the court argued that the suspension of the enforcement of German court's injunction order would cause only very limited damage to conversant, since it would not affect conversant's other litigation rights before the German courts. Finally, the Supreme People's Court in China pointed out that neither public interest or the comity principle would be harmed. Regarding the latter, the court further elaborated that the Chinese litigation started before the German action, and the anti-suit injunction would not harm the subsequent German trial and would not affect the validity of the German ruling. In general, we think that the anti-suit injunction granted by the Supreme People's Court in China in Huawei versus Conversant case considered a couple of key factors in international practice to determine whether an anti-suit injunction should be granted or not. Following the decision made by the Supreme People's Court in Huawei versus Conversant case, 3 other anti-suit injunctions were issued in Oppo versus Sharp case, Xiaomi versus IDC case, and the Samsung versus Ericsson case since 2020, in which the Chinese courts expanded the scope of anti-suit injunctions case by case. In Oppo versus Sharp case, the court in Shenzhen prohibited Sharp from filing new patent infringement suits on its SEPs against Oppo in other countries. In Xiaomi versus IDC case, the anti-suit injunction further expanded that the court in Wuhan ordered ITC not to seek an injunction against Xiaomi in China or in any other countries in the world for the infringement of its SEPs, and not request from any court in the world to on the determination of SEP royalty terms. An even wider anti-suit injunction was issued by the Wuhan court in the Ericsson versus Samsung case. In addition to the similar costs that the court in Wuhan granted in the Xiaomi and IDC case, the court further requested the Ericsson not to seek an anti-suit injunction anywhere in the world. Although each court in these 3 cases provided certain analysis on the specific factors considered by them in granting anti-suit injunctions. However, I think it is regrettable that they failed to provide the further concrete analysis regarding the rationality in granting such a wide anti-suit injunction, especially the consideration on the proper balance between the judicial sovereignty and the comity principle. So last, let's look at a few different opinions and views from the judges and IP experts in China. In upholding the decision in Oppo versus Sharp case, the Supreme People's Court celebrated as the emergence of China as a guide instead, rather than a follower in setting international rules. So Mr. Jian Junzhu, a renowned IP judge from the court in Shenzhen, reminded the IP judges in China that they need to consider the proper balance between the judicial sovereignty and the comity principle carefully when granting anti-suit injunctions in China. More IP attorneys and legal professors in China view the insurance of anti-suit injunctions more prudently. For example, Mr. Qi Shanzhao, a senior attorney from a famous IP firm in Beijing, held that the current disputes between anti-suit injunctions and anti-suit injunctions derailed the original intent of establishing anti-suit injunctions, which is to reduce the abuse of litigation. Mr. Yuan Zhaosun, a well-known IP professor in China, even criticized that there are no winners in the battle of anti-suit injunctions, anti-suit injunctions, and the anti-suit injunctions in the global ICP litigation. So personally, I believe that with the emergence of more and more different and calm voices on the insurance of anti-suit injunctions, the Chinese courts would consider taking a more balanced position and approach to engage in the global ICP litigation in the future days. That's all for my presentation today. Thank you.
Thank you, Amy. That was a wonderful, detailed, and clear presentation of a complex topic, but one that's certainly on the minds of many intellectual property practitioners with respect to China right now. And I think so procedurally, how I think we'll proceed with the panel is I'm going to throw out some questions to the panelists to facilitate some further discussion on some of the really interesting topics that have been raised. And of course, anyone who is listening, anyone in the audience can feel free to, as Michelle just said in a message she sent a few moments ago, please feel free to send messages via the Q&A box. We will get to audience questions as well. It looks like there is at least one question in the Q&A box. But I would like to, before getting to that, ask Amy a question about the ASIs and China's general IP strategy. Now, this is not to say that Chinese courts are necessarily seeking to advance China's IP strategy directly through the issuance of anti-suit injunctions, and that they're really just deciding a case before them. But I have to wonder, to what extent are anti-suit injunctions part of a broader, at least possible strategy? At least the optics suggest that Chinese courts have been using, whether it's ASIs or maybe the anti-monopoly law as forms, and certainly FRAND and standard essential patents as a form of industrial policy. Are anti-suit injunctions and in Chinese courts declaration of essentially the ability to name and determine FRAND, set global FRAND rates, just a way to continue to ensure that, as Ben suggested, FRAND remain a quote unquote friend of Chinese companies. To what extent does this reflect maybe a broader effort to use standard essential patents and other or FRAND and other mechanisms, rather, as a form of industrial policy in China?
Yeah, I think maybe many legal personnel in this industry, they would think that the Chinese government or some Chinese people, they tend to use the anti-suit injunction, French, and other litigation tactics as a kind of industry measures or strategy to protect the Chinese industry. I think especially from anti-suit injunction perspective, I think probably the answer is, as you could see from my introduction of the typical cases in China. However, when we look at more broadly, we also have to view that if from a broader perspective, for example, like the insurance of the anti-suit injunction by the Chinese courts, actually for example, like the Oppo versus Sharp case, it immediately caused some kind of negative chain reactions. For example, like the anti-suit injunctions issued by the other foreign courts, which I believe was not the cause in China they originally expected. Actually, we all understand that the intention from the Chinese courts to be actively participant in the SEP global litigation. However, the global SEP litigation or other global patent campaign is far more complicated than they originally thought. When you become an active participant in the SEP litigation globally, you would have to face that more complex issues in front of you, which is totally out of the original expectation. So which is a very complex issue for especially for the newcomers from China who want to actively participate in the global SEP litigation. So it is not a very, although probably they have some original intention to set China as a jurisdiction of choice, but the final result of the actual fact is far more complicated. This is my initial thoughts. Yeah.
Great. So I guess that raises the related question of, is this, is this an approach? And I'll throw this out to David and Ben as well. Is this an approach that's well suited to China's current needs? Is this, and I don't just mean the anti-suit injunctions, but again, this includes a sort of at least I'm thinking of it as maybe related to, and maybe rightly or wrongly, but related to a broader set of approaches or policies or practices that have tended to that are, I think, maybe intended to benefit Chinese stakeholders, including things like technology transfer requirements that would require a company, in order to have market access, so these are sort of regulations tied to market access, would be required to transfer technological know-how or trade secrets or that sort of thing to Chinese partners in order to be able to participate in the market. Are these ultimately, approaches that are in China's interest in terms of developing national innovative capacity, and participating in the global market, in the global marketplace?
I think that's a great question. And I think one thing that, one of Amy's slides, like there's individuals that said that the Sharp decision was excellent, or showed that, China had a say in these SCP types of litigation, because we have been very Western centric, right? We've had most of these cases heard in the US, and if not in Texas. I mean, a Chinese company patents are these SCP rates being decided for these Chinese companies in Texas. Does that make sense? Is that fair for a Chinese company? Or even in Germany, a lot of these cases have been in Germany. Is that fair when that isn't their home court? There's been discussion in the industry about whether or not it's even a better idea to have this in sort of like a more of a neutral environment, like some sort of international arbitration type of tribunal that is experts in determining the technology and what the worth of these SCPs are and what the reasonable royalty is. And so, given how international and the technology is being used across the board, and how countries throughout the world are now significant players in technology, I think it makes sense to do something more like that. I mean, I think good for China to make that point through the case with Oppo and Sharp. They're showing that, they're stating basically that, why can't we make a decision as well, where our companies are being affected by these particular issues?
Ben, I don't know if you had any thoughts or wanted to.
I absolutely agree. It's natural progression of companies.
Ben, sorry, your audio is not clear, unfortunately. I don't know if there's something maybe you can.
Is it better now?
It's still, at least on my end.
Maybe turn off and turn on, like mute and unmute, maybe.
No, unfortunately, it's still. Maybe it would make sense to log out and log back in or something, and just have it kind of refresh the. So go ahead and hold that thought. I only thought because Ben specifically raised Frand as a as a one mechanism by which at least some in the SEP and patent community have suggested that Chinese courts have been again sort of making industrial decisions informed maybe more by industrial policy than law. And again, this is not to say that that doesn't happen elsewhere as well. And I think that David raised some great points in that regard. But well, let me get to our the question, one question so far that has been raised from viewers, which is from William Fisher. And I don't know if this is William Fisher, my former professor at Harvard. If it is William Terry Fisher, then hi, Terry, welcome. If it's not, welcome anyway. So it says, how has the current US-China geopolitical situation impacted foreign-related IP litigation in China or cross-border licensing, if at all? So two questions. That's the first. So how is the current it just okay, here it is. How has the current US China geopolitical situation impacted foreign related IP litigation in China or cross-licensing. And one response that I would like to jump in with about that I don't think has been discussed yet is that, in fact, foreign IP litigation in China, in other words, IP litigation in which one party is of foreign origins, not a non-Chinese party, is exceedingly small. So even though IP litigation in China is far and away the most IP litigious country in the world, it is well under 2% of those cases involve a non-Chinese party. So I don't know whether there is much of a pool of sort of foreign related IP litigation in China to be affected by the current sort of relationship, and obviously the evolving relationship between China and the U.S. And it's certainly at a at a low point. But anyway, I'll certainly throw this out to the panelists as well. But that would be my first reaction with respect to that question. There's an additional question which was about the impact of COVID-19 travel restrictions in China and how that would impact foreign related IP litigation or cross-border licensing. Obviously, cross-border licensing a little bit different from litigation, but I'd love to hear what the panelists have to say about this.
From the statistics I have, hi Skip, I'm going to see your question. From what I see in terms of the statistics that I was actually talking about was mostly overseas litigation, overseas company litigation in mainland China. COVID hasn't affected it, it doesn't look like, and the bilateral relations hasn't really affected it. From 2019 to 2021, cases filed by foreign companies has increased probably by over twofold, and it seems like it's across the board the case in terms of all the other courts too. It's about twofold or a little less than twofold during COVID and during these last few years. So it's highly active still in terms of litigation, but I'll let Ben talk about the licensing aspects.
Ben, do you want to give your audio a try?
Yeah, can people hear me better?
Yes, we can.
Is it a little bit better now? Okay, good. So, in being very practical, I think the question asked about, geopolitics and also COVID-19 travel restrictions and the impact on litigation or licensing. Let's talk about travel first. Day in, day out, I'm sure it's the same with David. If you manage cross-border litigation, especially when it comes to IP litigation in America, there's a lot of depositions and interviews with experts, engineers, and executives. A lot of those cannot easily happen these days. Especially it becomes difficult when the Western world has opened up quite a bit. The American judges increasingly find it hard to understand why witnesses or executives from China cannot travel to America to be deposed. In the past, if that's a difficulty, the compromise could be getting someone to be deposed by opposing counsel in Hong Kong. But now even Hong Kong has a very restrictive travel regulations because of COVID-19. So that has become quite a headache. When it comes to licensing, all kinds of companies who negotiate these kind of deals, especially if you are a licensor, if you have a sophisticated team, these people need to fly around the world to interview with and negotiate with all kinds of companies. And China is still in the early days of that learning curve to become an international IP licensing powerhouse, how do these people get trained? By participating in negotiations. Of course, they can do Zoom like this, but it's still a little bit different if you show up and sit in front of people across the table, and even if there's a language barrier, you pick up a lot more body language and nuance in that kind of discussion. A big part of that is missing now, not helpful. When it comes to geopolitics and potential impact on litigation or licensing, I'm not so sure. In the long term, there might be some impact when it comes to R&D. For example, there's more suspicion in China, also in America, about researchers or companies from the other country. That could be obstacle to collaboration, to exchange of ideas. But the impact will be more longer term. The travel restrictions really is giving the practitioners a lot of headache right now.
Yeah, so maybe let me add some comments from litigation perspectives, since I personally manage a lot of litigation in China. So for the first issue regarding the impacts by the sensitive environment between US and China, I think for me, at least based on my personal experience, I think even for the cases in which one party is a foreign company and the other party is a Chinese entity, I think in most cases, especially in the large cities like Beijing or Shanghai, most of course they could keep neutral on such sensitive cases, unless the other party is very powerful state-owned company in China, in which probably the judges in China, they would have more concerns whether they need to carefully consider to protect the interests of the big Chinese companies in suit. However, another observation from my end, that is, even for the sensitive cases in China where the other one party is a big state-owned company, the costs, sometimes the judges probably they would be more cautious because they do not want to cause more criticism, especially from other countries, to criticize that the judges in China, they cannot keep neutral and fairness on such to determine the such cases. So probably some of them, they will tend to push both parties to settle instead of litigating the cases. This is my personal observation. And regarding the impact by the pandemic, there is huge impacts on our cases in China. I think at least from two perspectives. The first perspective is it will make the ending date or deadline of our cases more unpredictable. This is, I have to say, it's very, for example, like we have a case in China, which is typically the whole process will just last for 2 years, but our case has lasted for 4 years. And so far, we even haven't received a decision from the court for the first instance. This is really prolonged process. Another big impact is because we have the strict restrictions on travel. So it means that most of our current cases in China, we cannot hold for the in-person trial hearings. So we have to attend the online hearing. But the online hearing has many restrictions. For example, we cannot observe the body language or the faces of the judges carefully, or the the body language of the other party, which really impact the performance of our outside counsels, especially in some big cases. And although there would be some improvement of the online tools, however, the restrictions, I think it's still there, and it is very difficult to improve in the real practice. So there are huge impacts on our cases in China. Because of the restriction of the pandemic. And personally, as a litigator in China, I do hope that in the future, if there would be no pandemic, we could go back to our normal in-person hearing. Yeah. Thank you.
And that raises an interesting point. And by the way, I will just say those were great responses. And I think I might have misinterpreted the question a little bit when I responded, because I was under the impression that it was more about impacted the rate of foreign related IP litigation, or the amount of foreign related IP litigation in China, which, as I said, is surprisingly low, and something that I think often people are also surprised to learn just how much, in fact, China's IP litigation is really parties, purely sort of domestic conflicts, Chinese parties suing other Chinese parties. But on Amy's last point, and also what Ben raised about the importance of kind of being in person, one of the interesting things that China is often cited for, at least increasingly, is the use of technologies in litigation, the use of whether it's remote access or video conferencing technologies in litigation, in hearings, as well as even the use of AI, artificial intelligence, in even in aiding judges in resolving disputes, especially in IP cases. China is seen as a kind of at the global vanguard in these areas. But I'm hearing some interesting comments that suggest that maybe these aren't necessarily great trends. Maybe it is better to hear cases in person. On the other hand, for example, with regard to copyright, there's about 200,000 copyright cases filed in China annually. How do you handle that kind of workload if you don't have some kind of technological assistance? So I'd be interested in hearing what the panelists think of these trends. David, I saw you nodding. Did you have any thoughts on this?
You're gonna put me on the spot. I think, I hate to say that things are going to get automated throughout the practice of law, including the courts. I think that's a reality, and that will happen. I don't know if it's going to happen entirely in my lifetime, but I probably will see a lot of it happening, and we're already seeing it in the way a lot of the activities that we do as lawyers is automated or has AI involved. So I personally don't like any maybe a more traditional in terms of having a judge actually hear a case in person and going. I think there's something about that, and that's part of lawyering and being part of a practice of law. And and as Ben mentioned, law, the rule of law is so new in China that they are able to innovate that quickly. So maybe they're going to be ahead of the US in that sense, and they are able to change a lot faster. So China may be at the forefront of that, just because they're able to adjust as more quickly than we are, given that the rule of law is so new, and a lot of the ways that law is practiced in China is a little bit more modern. And maybe we have to learn from that.
Yeah, legal leapfrogging. Ben or Amy? Any thoughts on that?
Amy, go ahead. Amy, you probably handle more of the other cases in China. I mostly just negotiate cross-border licensing deals. Hopefully, people don't get to lawsuits.
Yeah, so for me, as David just said, I believe, although I have to say that I don't like the remote hearing in China right now, but I also believe that when we have more and more experience to handle the online hearings in the future by the improvement of the technical tools, we believe that the experience to attend the online hearings will be improved. Will be improved in the future days. But personally, I still think that, especially in terms of the complex, like the patent cases, which is still very difficult to get a very good, great experience in attending the online hearings, because in the complex patent cases, you need to explain the typical, the technical issue, complex technical issues and legal issues to the court very specifically. If you just attend the hearings online, it is, at least according to our experience, it is very difficult for you to do such a very detailed and concrete presentation to the judges to make them fully understand. But for other cases which do not have involved so many complex legal or technical issues, it is much easier for the judges to understand the key arguments from each party. I think maybe and this simple cases maybe account for maybe I think at least 2/3 of the cases in China. So it's make the judges much easier to understand the key issues of these simpler cases. I even just attending the online hearings for those simple cases. It is not a huge issue for the parties and the judges in China. Yeah.
Great, thank you. And yeah, they're now, for example, Hangzhou internet courts dealing with internet-related issues. You can file everything, handle everything. In fact, the proceeding occurs all through the Weixin or WeChat app. So China is certainly very cutting edge in this, and it'll be worth watching China at the sort of global vanguard of adjudication technologies. So we have about 3 minutes left, and what I'd like to do, and maybe it's unfair to do in the final 3 minutes, but throw out maybe the big question relating to China and IP and the role of IP in China's role as a global leader. Many people have suggested over the years that China, the intellectual property environment in China will improve, the enforcement environment will improve when China becomes, and China will become more of a rule maker, an IP rule maker rather than, or a norm maker rather than a norm taker. When the domestic industrial and economic situation is such that intellectual property laws on balance are more beneficial to Chinese stakeholders than not. And so it's interesting because I see now reports that, for example, Generation Z, now in fact, South China Morning Post just had a report that Generation Z, now there's a strong preference for domestic Chinese brands, whereas 5-10 years ago, it would have been for foreign brands in fashion, sportswear, that sort of thing. You see that domestic films now dominate the Chinese box office. Now, of course, there's government involvement and intervention that kind of affects that and shapes the availability and market access issues. But the broader question is Chinese IP enforcement, Chinese IP protection, in your view, generally, broadly, is it improving? Is it improving? Is it getting better? Is it getting worse? Is it staying the same? And have we reached that point where now it makes more sense in China for Chinese, economic sense for China to be more invested in a stronger intellectual property regime? And I guess it's actually 2:30. I didn't mean to fill up the time with my question, but maybe if the host will indulge us, maybe 30 or 45 seconds each for a quick answer to this question. Maybe I'll start with David.
Thank you again for having us, and thank you for moderating, Professor Priest. I think China certainly is going to change the way they handle a lot of these enforcement actions. I think we're going to see more enforcement actions there as China becomes, Chinese companies become more of the main innovators. I was just in Palo Alto the other day and driving behind a Stanford bus. And I remember riding those buses when I was a student, and it said BYD. It's like, that's a Chinese company. I was like, wow, they're manufacturing these electric buses. We're going to see a lot of change in terms of the industries, and especially the technology companies, in terms of Chinese companies really leading it. And that's what Ben and Amy have been talking about. And I think the courts are going to have to change in terms of their attitude and the way that intellectual property is enforced in China. And having those companies are more sophisticated than ever too, and they're filing patents around the world. And in fact, they may become the significant SCP holders, and they may be leading the way in terms of how technology is driven.
Thanks. Thank you. Ben, any thoughts on that?
Sure. Very quickly, Chinese companies are inventive. The competition in this market is cutthroat, and one of the edge for the companies to have is to have your IP portfolio and potentially enforce it or cross-license it. And most of the deals the contentious matters that we handle on behalf of Chinese companies typically is to sue other Chinese companies in America oftentimes. So, which is great news for lawyers.
Amy, any thoughts?
Yeah, thanks, Professor. I think the short answer is yeah, they are improving. And I believe that both the Chinese companies and the Chinese judges, they are smart and intelligent. So they can learn from others and also learn from their past. So I totally believe they would continue improving in the future. Yeah.
All right. Well, thank you very much. I apologize that we're a couple of minutes over time. Thank you so much to our brilliant panelists, and to the Journal, and to Santa Clara Law School for inviting us.
Yeah, thank you all. Thanks for having us.
Thank you.
Thank you.
Bye.
Bye, everyone.
Thank you so much, Professor Priest, Amy, and Ben and David, for an informative discussion. So with that concludes our first panel. We will now go on a 10-minute break, and our second panel will start around 2:40. See you soon.
Hi, everyone. We will be starting in just a few minutes. Okay. Hello, everyone. We will start our next panel on international trade and cross-border regulation. Please also remember that you can receive up to 3.75 hours of MCLE credit. Please fill out the Google form, which we will provide in the chat box. You only have to fill it out once. So now our second panel is moderated by Professor Anna Han from Santa Clara Law. Professor Han specializes in Chinese law, corporate law, startup businesses, and technology licensing. Please welcome Professor Han.
Thank you for that introduction, Diane. Good afternoon, and thank you all for being here today. In the midst of all the tension around the world, trade and investment has been brought to the forefront, not just a tool of commerce, but also diplomacy and conflict. So we're delighted to have with us today 3 distinguished panelists who share their experience and who are experts in the area of trade and investment. And they are here, and as been told, my name is Anna Han, and I've been teaching here at Santa Clara for just, let's say, many, many years. And I'm so happy to be here today to welcome our panelists. First is with us is Professor Alan Sykes of Stanford University School of Law. Professor Sykes is an expert in international economic law, trade, and numerous other areas. We also have with us Ms. Ruming Liu. She's a partner with the firm of Magstone here in California, and she specializes in advising clients on investing and trading with China. Last but not least, we have from Tokyo, Professor Mitsuo Matsushita, Professor Emeritus of Tokyo University, and a renowned expert in international economic law, and a former member of the appellate body of the WTO. So we're grateful to them for coming here today and sharing with us their expertise. The way we're going to proceed is each panelist, starting with Professor Sykes, will do their presentations. We'll leave all the questions to the end. So feel free to type them into the chat, into the Q&A section of your screen, but we will hold them until the end. Again, my appreciation for the panelists and the audience, and I will let Professor Sykes take over.
Okay, thank you very much. I'm attempting to share my screen. Is it showing up?
Yes.
Great, okay, perfect. So I've got a little PowerPoint here. For those of you who don't know me, and that's probably most of you, I'm a law and economics type, and I thought I would kick off this panel by giving a perspective from both the legal and the economic sides of things about the challenges that China has posed in the world trading system. It has become an enormously important country in the trading system, and that has begotten some difficulties that were not really expected when China first entered into the global trade system. So just as a quick bit of background for those of you unfamiliar, modern international trade law, as opposed to domestic international trade law, began basically in 1947 with the General Agreement on Tariffs and Trade. This followed World War II. And prior to the war, of course, there was a terrible tariff war in the 1930s, triggered by the Smoot-Hawley tariff of 1930 in the United States. Tariffs went up and trade was choked off. And the idea of the GATT was that in a post-war economic order, it would result in negotiated tariff reductions. There would be a normal market response to lower tariffs, and then world trade would expand and prosperity would begin to return, unlike much of the 1930s. And GATT was basically quite successful in that regard. And it was eventually subsumed into the new WTO, World Trade Organization, when the WTO was started in 1994. GATT just became a part of it. A little bit on China and world trade. Historically, China was a signatory to the original GATT, but after the Communist Revolution in 1949, the government that had relocated to Taiwan withdrew China from the GATT, and China lost its most favored nation status. Most favored nation tariffs are the tariffs that GATT members extend to each other and reflect the negotiated tariff reductions since 1947. Some countries, though, gave China temporary most favored nation status anyway, even though it was not a member of GATT. The United States began to do so in 1980. But this status was always temporary and revocable. It had to be renewed periodically, and there were political battles over whether to renew it or not. In that context, China, now I'm talking not about the Taiwan government, but the Beijing government, China expressed a desire to join the GATT in 1986 and was finally admitted after the GATT had turned into the WTO in 2001. And just a little bit of data on China's world trade statistics. Here we have exports of goods and services in current dollars. So this is all inflation adjusted. And you can see that China was basically a non-player in world trade in the 70s and 80s and even in the 90s. But beginning around 2000 and really taking off after then. Remember, China joined the WTO in 2001. China has grown just exponentially as a player in world trade, to the point that it's now the world's largest exporting country. So it's gone from negligible to the biggest exporter in the world over a half a century. The increase in exports from 2000 to 2020 was over 1,000%. China's imports have also grown dramatically, though not quite as much. They run a consistent balance of trade surplus. The most important point is that this rapid, extraordinary growth in China's presence was not anticipated at the time that China joined the WTO, and I'll say more about why in a moment. The rapid growth of China has created some issues that were unexpected. So I'm going to focus on three unexpected problems associated with China in the world trading system. When China negotiated accession, which happened in 2001, there was the usual give and take. There was an accession protocol in which China accepted some important commitments. But the background assumption on the part of its counterparties, particularly countries like the United States, was that China's export presence wasn't going to change that much. The reason being that China had already, as I noted, received most favored nation treatment on a voluntary basis prior to 2001. And so the thought was the tariffs on China's goods being exported to places like the United States would basically be the same as they had been for a number of years, and there wouldn't be any sort of dramatic change. This turned out to be a completely wrong assumption. It turns out that in the days before China's accession, there was always considerable uncertainty as to whether or not China's most favored nation status would be renewed. And once that uncertainty was removed by China's accession, China's export sector just really exploded. And there's a well-known paper in the American Economic Review a few years back that calculates that China is getting permanent most favored nation status through its WTO accession was equivalent to about a 13% tariff reduction. And that begat a huge increase in China's manufacturing exports, especially in countries like the United States. This caused a lot of dislocation. The most well-cited paper in international economics in the last 20 years is a paper that begins with the first part of the title is The China Syndrome in the American Economic Review. This inaugurated a literature on the China shock. And the basic proposition from that literature is that China's permanent accession to the WTO resulted in the loss of thousands, hundreds of thousands of manufacturing jobs in the United States, and affected communities and workers have been very slow to adjust. And this has become a very significant political issue through the years. Second unexpected problem associated with China, China's aggressive industrial policy. Another background assumption at the time that China joined the WTO was that China was transitioning to a market economy. No one expected a Western-style democracy to emerge overnight, but the thought was that the economic reforms of Deng Xiaoping were going to move the economy, at least in the direction of market allocation of resources. Those expectations were also wrong. China under President Xi has maintained extensive state intervention in the economy through its broad industrial policy. It not long ago announced in 2015 a policy called Made in China 2025, which is a government policy to target growth in advanced technology sectors, information technology, green energy, robotics, and others. The way that they're doing this is through large subsidies, estimated to amount to hundreds of billions of dollars to these industries over time, delivered through direct aid, subsidized loans, and the like. Economists will argue over the sort of global welfare effects of these subsidies, and I'll say a little bit more about that in a moment. But there's no question that China's rapid growth in these priority areas under China 2025 and related sectors has been perceived as unfair and has raised very difficult political issues in many countries, including the United States. So that was the second problem. The third unexpected problem is the reliability of market access to the Chinese market for those who wish to export to China. Obviously, China's industrial policies impede the ability of exporters of competing goods to sell into China, but the problem is considerably deeper than that. China's state-owned enterprises are extensive in a lot of sectors. They are subservient to government preferences on matters of international trade. My colleague here at Stanford, Curtis Milhaupt, has also documented that even the so-called private companies in China that aren't state-owned actually have representatives of the Chinese Communist Party on their boards of directors. And the consequence is a perception which I think is to a great degree accurate in many sectors, that China is kind of a command and control economy when it comes to imports, that the nominal tariff rates that China charges don't really determine market outcomes. It's up to the government to decide whether it wants more imports or not in a particular sector. So the result is that China's tariff commitments under GATT Article 2 don't provide secure market access to foreign exporters the same way they do for exporters in market economies. The government can control import volumes without the need to use the traditional instruments of trade policy. And therefore, the perception has arisen that China kind of got a lopsided deal when it joined the WTO, that it hasn't really reciprocated. It got permanent most favored nation status from all the other members, but its own market access promises are not really credible. And this was, as you may recall, trumpeted widely by the Trump administration with its constant focus on the bilateral trade imbalance between the US and China. There are other unexpected issues associated with China and the WTO. Intellectual property theft, forced technology transfer, that was the subject of an earlier panel, and I'll leave those issues to the side. Allegations of currency manipulation have also been made at times. I'm going to leave that to the side as well in the interest of time, although I'm happy to take some questions on that. But let me continue with a focus on the three unexpected problems that I outlined before: the China shock, China's industrial policy, and reliable access to the Chinese market. What can be done? What to do? The China shock, first of all. The China shock dealt a big blow to domestic support for liberal trade in the United States. It wasn't the only blow, but it was a big part of the blow that has had a political impact on both sides of the aisle, with everyone from Donald Trump to Elizabeth Warren and Bernie Sanders being quite protectionist minded in modern era. But the China shock is largely behind us. It's the effects of this equivalent to 13% tariff cut have worked its way through. We don't expect the kind of export growth that we saw after China's accession going forward. So it's not something that we really need to do anything about now. We're not clear that we could really, but it is a lesson for future policy making and trade. It's something that tells us that although the efficiency case for liberal trade is compelling. The political consequences of liberal trade can be quite difficult, and the income distribution effects of liberal trade can also be quite difficult. And we need to think more and harder about US policy in those areas going forward. But the China shock per se is over. What about China's aggressive industrial policy? What should we do there? Let me divide that issue into two parts. First of all, the effects of China's policy on its exports, and secondly, the effect on its imports. Starting with the exports, the issue of what we should do in response is controversial. Free marketeers would say, well, when China subsidizes its industries and lowers their prices to the rest of the world, as long as that doesn't result in a Chinese monopoly that can be exploited down the road, in effect, China is writing a check to the rest of the world, and the rest of the world shouldn't be upset about it. If anything, they should kind of be grateful. So that perspective suggests that there's not really any need to respond in a systematic way to China's industrial policies, subject to the caveat that you'd be concerned about the emergence of Chinese monopoly in certain areas, and you have to bear that in mind as a caveat. But on the other side of the argument, there are the folks who think that China's policies create an unfair playing field for its competitors. Countries like the United States have a vital interest in being leaders in these prioritized advanced technology industries, partly for economic reasons, because the economic returns in those industries may be higher than elsewhere, but also partly for national security reasons. We wouldn't want a world in which we became dependent on possibly unstable sources of supply from abroad for these advanced technologies. And so from this perspective, a response might be necessary. One option, of course, would be to have our own industrial policy where we match China's subsidization of targeted priority industries. But in the trade community, the response that's usually discussed is some sort of discipline on Chinese subsidies via international legal rules in the WTO and through what are called countervailing duties or countervailing measures, which are duties imposed by an importing nation on subsidized imports. And in that regard, there's already dozens of subsidy and countervailing duty cases against China. But the general sense is that the existing subsidies rules are inadequate to deal with China. One issue comes from the WTO appellate body, which rendered a decision on the concept of the public body some years ago, which had the effect of insulating state-owned enterprises in China, or at least some of them, from the findings that they are conferring subsidies. They were not to be treated as public bodies and therefore couldn't be dealt with through countervailing duty measures. This decision of the appellate body has received considerable criticism. They've tried to soften it a little bit since, but it's still on the books. But beyond that issue, the concerns are extensive as well. The trilateral trade ministers, US, EU, and Japan, a couple of years ago proposed a bunch of new subsidies rules that would expand the concept of prohibited subsidies under WTO law to include things like subsidies to ailing enterprises and enterprises in sectors with overcapacity such as steel, reverse the burden of proof on the injury issue in countervailing duty cases, make prohibited any subsidy that wasn't properly notified to the WTO, develop a methodology for valuing China's subsidies similar to the non-market economy methods that were used in dumping cases. And these were all put on the table by the trilateral group. The proposal is clearly directed at China. You can wonder about their wisdom. They would empower administrative bodies like the US Department of Commerce to use countervailing duties left and right based on dubious premises against China, and it might very well be the subject of protectionist capture. But even if you're not going to reject this approach on those grounds, the other profound problem is that to change the subsidies rules in the WTO, China would have to agree. Where is the leverage to get them to do that? The final question is market access. What to do about that? It doesn't look like China is going to become a market economy anytime soon. Therefore, the credibility of their conventional market access commitments, such as tariff commitments, is going to remain weak. It's interesting to note that China isn't the first non-market economy to come into the GATT system. There were a number of much smaller centrally planned economies joining the GATT back in the earlier days when Eastern Europe was allowed to be a little bit less controlled by the Soviets and Russia. And so, for example, when Poland came into the GATT in 1967, it was a command and control economy. No one thought that their tariff commitments were really worth anything because the government would decide what to import regardless of the nominal tariff rates. And so in negotiating Poland's accession, the rest of the GATT said, look, we're not so concerned about what your nominal tariff rates are, but you got to promise us to grow your imports by a certain amount every year. Initially, it was 7%, and that was subject to review. Something similar could be done with China today in principle. If commitments of an aggregate sort like Poland's were inadequate because of sectoral concerns about the effects of market access in particular sectors in China, the commitments could be based on sectors and not just an overall aggregate commitment. This is a kind of policy that economists often call managed trade, and they use that term derisively because it is government-to-government negotiated trade rather than market allocation trade. But if there is no free market, the question becomes, is managed trade better than nothing? Maybe yes, maybe no. But again, there's the problem. The fundamental problem is, why would China agree to this? They're already in the WTO. What would persuade them to make new commitments of this sort? So let me conclude with a few thoughts on how one might begin to create some leverage with China. Obviously, there's always the possibility of issue linkage. You do something for us on trade, we'll do something for you on some other area. I'm not sure that there's an issue that we would be willing to link in that fashion at this point. It would be enough to induce China to move in our direction on the trade issues. An alternative strategy is some sort of decoupling of the economies as a punishment for its trade policy and industrial policy in China, and then try to use the threat of decoupling or the tariffs that would accomplish that as leverage to bring them to the negotiating table. That was the strategy of the Trump administration, which used Section 301 of the '74 Trade Act to impose very substantial tariffs on lots of Chinese imports, and they're still in place. One problem with this approach is that it imposes heavy costs on the US as the tariffs pass through in large measure to US buyers, according to the economic research. They can also result in a retaliatory tariff by China, which in fact the Trump tariffs did, and lead to something of a trade war rather than a lot of movement from China on issues of concern. Although the Trump strategy did produce the so-called Phase 1 trade agreement with China, in which China did make commitments to increase imports from the United States by certain quantitative targets, but that agreement was not lived up to by China. They would say it was because of COVID. We would perhaps say that it was other factors as well, but that just didn't work terribly well. To create leverage through this sort of threat of decoupling more effectively, it has to be, I think, multilateral. It has to be a united front of a bunch of different countries coming together to say to China, we're going to cut off Europe market access to us unless you do some reforms that we think really need to be done. This was part of the thinking behind the Trans-Pacific Partnership originally, to create a club that China would want to join and use its leverage to induce Chinese reform. That, of course, didn't work because, in part, President Trump pulled out of the Trans-Pacific Partnership. China had a counter strategy, which was the Regional Comprehensive Economic Partnership, which is a club that we're not a member of. But in principle, I think you could redeploy this sort of threat of decoupling strategy if you had a large enough coalition of the willing, Europe, Japan, United States, Canada, Australia, and so on. If you could get them all together, you might be able to exert some real pressure. Absent some sort of multilateral coalition of the willing along those lines, I don't know that we have the leverage to move China significantly off where it is today. And I'll end with that somewhat pessimistic note, but thank you for inviting me to participate, and I look forward to your questions. Maybe muted, Anna.
I am muted. Okay, I can unmute myself. Thank you very much for those really insightful comments, and you raised some really interesting questions and possibilities going forward. I hope that we can discuss it during the Q&A session. Now, Ms. Liu is going to talk about investing in China, particularly US-China regulations of each other's investments. So, please.
Thank you, Professor Han. I'm very glad to be here, and welcome to everyone in the audience. Thank you for joining us. So I work a lot on cross-border transactions, and I used to practice law in China, Hong Kong, and primarily in the US. And so although I'm not a CFIUS attorney, but I'm more on the corporate side on merchant financing and the merger and acquisition transactions. However, because of our client base, many of the deals and transactions we represented were more or less CFIUS issues and analysis. So today we are talking about US-China trade and investment and why CFIUS matters. The reason is because the new development on CFIUS related laws is considered the most influential laws in recent years that probably impacted the China investment in the US. I'm not sure today's audience knowledge in terms of CFIUS. I want to start a little bit of CFIUS 101, so we can all start from kind of the same foundation. So first, numerous studies have shown that foreign investment is important to US economy with respect to innovation, job growth and economic growth. However, not all foreign investment is considered benign, and that's where CFIUS steps in. So CFIUS is an interagency committee led by the Department of Treasury that reviews certain foreign direct investment for national security concerns. If CFIUS deems a foreign investment a national security threat, it can force the investor to pursue measures to mitigate the risks or recommend that the president prohibit the transaction or order divestiture of the past investment. So I listed here the members of CFIUS, including 16 departments, such like other than Treasury, there's Homeland Security, Commerce, Defense, State, Energy, etc. So usually once the case was filed, it was like on a case-by-case basis, and a small committee for a particular case will be formed, and the people who are in charge of a particular case will be from the various department who's more related to that particular case, and all information is confidential. So CFIUS are trying to keep business information in strict confidence. So there's a limited knowledge that public may have access. And then in the history, CFIUS more or less often occurs in M&A transactions for practice attorneys. So CFIUS rarely intervene or venture financing field. However, in recent years, especially after August 2008, since the new law, we call it FIRMA, the full name is the Foreign Investment Risk Review Modernization Act, they substantially expand the CFIUS jurisdiction. So before, the CFIUS jurisdiction more on how the foreign person could obtain control over a US business. Although control is widely interpreted, not only, for example, traditionally we consider as 50% of some voting shares, but more like even you through contract or other arrangement, you can control a company or dominant. You have certain like a veto rights over the important business decision that all can be considered as control. On the other hand, there's some like strict line if the investments less than 10% and considered passive, it will be excluded from CFIUS review. However, after FIRMA, the things are completely changed. So what we call cover transaction, that include even minority investment in business in certain sensitive US industry will be considered as under CFIUS regime. So FIRMA defines this sensitive business as TID business, which is critical infrastructure, critical technology. So we take the T, or collect or maintain sensitive US personal data, so TID. And Yeah, and as a result, such investment target becomes subject to, voluntary or even mandatory declaration filing obligations. So previously, CFIUS review is only a voluntary process. So if the parties they're going to do an M&A deal and they're going to evaluate the risk and see whether there's some, national security concerns and how much is the risk. If it's considered moderate or high, parties intend to submit the transaction for CFIUS filing. So the benefits of submit for CFIUS filing is that once the CFIUS rule is clear, then there's no longer retroactive action towards that same transaction. However, the parties can totally choose not to make the filing. It opened up the box that CFIUS could, over the years, retroactively take action and initiate an investigation. However, in the past, this kind of situation is rare. After FIRMA, there's two key procedure trends emerged, which is different from what I said just now, is that CFIUS has begun investing more non-notified transactions. So they start contacting parties in non-notified transactions. For example, in 2020, there are 117 times investigation initiated by CFIUS, more than the total number in 2018 and 2019. And also for Chinese investment, we see more short form declaration, which is mandatory rather than voluntary filings. So it goes to the mandatory and voluntary. The mandatory started after the FIRMA took effect. So the big difference is without filing the mandatory filing, the parties cannot close the deal. So it's very strict. If you are subject to mandatory filing and you didn't make the file, then the parties could subject to a big penalty up to the whole value of the transactions. And the possible actions after filing the mandatory declaration, which is a kind of a short form rather than a long notice like a traditional CFIUS filing, only 5 pages, which is intended to shorten the review period and expedite the process. However, in practice, it's rarely, unless the case is really straightforward and simple, most of the case is hard to get clear at the mandatory declaration stage. The reason is a lot of case, if the CFIUS officer review, they rely on a lot of background information. They need to ask questions, but 5 pages is too short for the officer to review the whole picture. So most of the case, the parties got informed that CFIUS is not able to conclude the actions on the basis of the declaration, and then parties may need to file a written notice, or CFIUS may issue a unilateral review of the transaction. So the biggest impact of this, FIRMA, not only the broaden the jurisdiction review and extended to the venture financing field, and also they have this mandatory declaration which extend the timing needed for closing a deal, especially in Silicon Valley where I located. Many of the venture financing deal got postponed, or the startup was forced to choose investor from a local investors or non-Chinese investors. Because of that, because the unpredictability of the transaction and the additional costs that need to spend on CFIUS analysis and filings. So, when a Chinese investor invests in the US, they, instead of just evaluating the target company's potential, they will have to consult with the target company first. Is your company's, for example, technology, a critical technology? Is your company's business, collect or maintain a sensitive US personal data? And if so, is a mandatory filing required? If not, whether the voluntary filing risk is high or low. So there's a lot of issues need to be considered for Chinese investors. So from this chart, you can see, between 2016 to 2018, each year, China's filing is the largest proportion of the notice filed before 2018. And after 2018, since FORMA already enacted, and Japanese investors become the #1 notice filing country. And from this chart, we can see a history of trend of Chinese VC investment in the US. So before 2010, it's still very limited, but after 2014, the numbers start climbing up and above 1 billion per year mark and hitting a peak of 4.7 billion in 2018. So back then, where I practiced in Silicon Valley, a lot of startups even looking for Chinese investment because they feel that it's easier to get Chinese money. However, the investment sharply dropped by almost half to 2.3 billion in 2019 after the enactment of FIRMA, which made certain venture transactions subject to CFIUS review and was estimated by certain, I'm not sure how accurate it is, but was estimated by independent research company that the Chinese investors abandoned deals worth more than 2.5 billion in the US in 2018 due to unresolved CFIUS concerns. So although the investment value grew again in 2020, it was not really because of the number of the deals, it's because of a few like large transactions that boost the total value. But the transaction number still dropped another 50. So comparatively, you can see US to China VC deals also dropped. I think partially also because of the tension between the two countries in terms of value and deal count. In 2020, there were 247 unique funding rounds, down from last year's total of 306. So total investment value dropped more sharply to 2.5 billion, just half of last year's total, and a fraction of the almost 20 billion reported in 2018. So in terms of the CFIUS example, so recent years, there's a lot of transactions being blocked or affected. So previously, between 2016 and 18, mostly on the semiconductor sector. And after and meanwhile, there are a few personal data sector deal was noticed and being reviewed. So FIRMA contains no definition or with respect to sensitive personal data, other than it refers to the data that may be exploited in a manner that threatens national security. So to address this, the regulations created two classes of sensitive personal data. So first, the sensitive personal data includes the results of an individual's genetic test, including any related genetic sequencing data, whenever such results constitute identifiable data. Second, sensitive personal data includes identifiable data, which could include, for example, financial data or data in your consumer report, or data including health or other types of insurance applications. And so between this 2016 to 2018, where the personal data sector review become rising up, then the CFIUS start paying more and more attention on the personal data issue. In 2019, CFIUS forced the Chinese gaming company Beijing Kunlun Techco to sell the US dating app Grindr, which it acquired in 2016. So that was a shock to a lot of people by then. Sorry, I think. I just realized I didn't use a slide performance. So it was a shock by then because Grindr was more a dating app instead of traditional what we call a critical technology company, and how a dating app could cause a national security issue. And turned out to be the CFIUS concern regarding Grindr seemed to focus on privacy, given that Grindr had tens of millions of users, most of whom were members of the LGBTQ community, and collected its users' personal location data, message, and HIV status. So reportedly, American officials worried the Chinese government could conceivably use information gathered to blackmail American officials or contractors, threatening national security. In May 2020, Quinlan finally announced CFIUS approval of a sale to an American buyer. So that was finally approved. So the next one, I'm going to touch a little bit upon the Trump ordered ByteDance, a Chinese social media company, to divest from TikTok. So TikTok in November 2017, ByteDance, which is a well-known Chinese social media company, they acquired the teen karaoke app Musical.ly for $1 billion as part of a strategy to break into the US market. Musical.ly was actually a popular social media company headquartered in Shanghai and founded by two Chinese entrepreneurs, Alex Zhu and Lu Yang. Our firm was representing Musical.ly to set up its US presence. So I still remember the first letter I sent to Lu Yu that, congratulations, your US company Musical.ly was formed back in 2015. But although our firm wasn't involved in the acquisition occurred in China, at the time it was acquired, Musical.ly was growing increasingly well and had already 60 million users in the US and Europe. And after the acquisition, ByteDance merged Musical.ly with its Douyin and become the Douyin's international version, TikTok. Because Musical.ly's presence is in the US, and so the acquisition of a US registered business by a Chinese company, which is ByteDance, become a coverage transaction. Although not required to make CFIUS filing, which is, that's probably why parties didn't even make any CFIUS filing. However, this deal attracted attention of some of the newspapers, which published articles suggesting that TikTok censors its content in line with Chinese foreign policy goals. And some US senators also reacted by calling on CFIUS to retroactively assess the national security risk posed by TikTok, especially they were referencing a 2017 Chinese national intelligence law, which was newly issued and requires Chinese companies to comply with the government's intelligence gathering operations. So CFIUS subsequently opened up an investigation. And this deal has been very well known, and it resulted in only the second ever instance of CFIUS litigation. And CFIUS, for the first time, actually failed in attempting to force divestiture. In August 2020, Trump formally ordered Chinese ByteDance to divest from TikTok. And the order followed a months-long investigation regarding especially TikTok's Chinese ownership post-American data security, potential foreign influence operation, and censorship. However, numerous complications arose from this action, especially because Trump had issued another executive order targeting TikTok 1 week before the CFIUS order, and the power granted to him under the International Emergency Economic Power Act to outright ban transaction with entire companies. So for Trump administration, forced divestiture soon went into this type of serious hurdles because first, this Trump own professed desire for the US government to take a cut of any TikTok sale provided evidence of, not purely based on the national security motives. And so although that time Trump gave the sale to Oracle his blessing, he also insists that ByteDance would be contributing $5 billion to an education fund, which ByteDance denied. Second, perhaps in part because of these confusing statements, so two different federal judges issued preliminary injunctions against the ETA order. This is because TikTok has a robust presence in the U.S. and people use the platform to do self-expression and share their political view, things like that. So it's already touched upon the First Amendment. And then the third, finally, the ByteDance and TikTok even sued the CFIUS action and accusing CFIUS of procedure violations, of rejecting mitigation measures, because usually CFIUS have always accepting mitigation measures if they find a deal has potential national security issue. They give a chance to the party to mitigate the issue. However, in TikTok case, they directly asked for divestiture. So that arose some issue with Administrative Procedure Act and due process clause. So the devastation later on was put on hold indefinitely. And later on, Biden government also revoked the ETA order. And instead of with a new order to evaluate the threats through rigorous evidence-based analysis. So there's a new order. So the future of the TikTok is still uncertain, but we're sure the government would gonna have some new actions about that. So now let's switch gears and look at how Chinese government policy impact Chinese individual and corporate investment in the US. So we oftentimes as US CFIUS and the new development bigly impact Chinese investment. On the other hand, China's own law and policy also changed the pattern of Chinese companies making outbound investment. So if you look at this page from 2012 to 2014, there's a lot of by the title, the implementation opinions on encouraging and guiding private enterprise to actually conduct overseas investment, or the opinion on supporting the stable growth of foreign trade, or the implementation of measures for the administration of the confirmation and recordation of overseas investment projects. All those kind of policy was intended to promote Chinese companies going out and increase its competitiveness and encourage them to promote their brands. However, later on, China experienced significant capital outflows, resulting downward pressure on the Chinese currency between 2016 to 2020. So we can see, for example, 2016, the National Development and Reform Commission issued an internal note on restricting certain outbound capital account transactions. And there are also new regulations imposed by the State Administration of Foreign Exchange that restricting the enterprise outbound investment. So over the years, and especially between 2013 to 2020, we see the policy. Sometime it was much tightened, and sometime was encouraged outbound. That also bring a lot of uncertainty to Chinese enterprise or individuals making outbound investment. And later on, because of the CFIUS change, the FIRMA issued, China investors, whenever they do a US investment, they feel panic. A lot of Chinese clients, when they consulting with us, they're gonna ask, is CFIUS permit or license can be obtained? So they have a lot of misunderstanding of the CFIUS procedure or what CFIUS is. But the whole environment and the continuous tension between the two countries actually bring a loud voice to the entrepreneurs trying to make outbound investment. So as ending notes, and there's no conclusion draw because although we see a lot of data, but there's no data actually show exactly which policy or which law impacted on how much of investment activities. But we do realize CFIUS and FIRMA was the most influential laws, and as well as the China's foreign exchange control policies, which prohibiting or restricting the Chinese enterprise to make outbound investment for some period of time. And unlike other laws, CFIUS has power to retroactively order divestiture or revocation against a Chinese company or other foreign investors. So those also bring like an internal fear of making investment. At the end, because of the political tension and combined with the fear of change of laws or regulations or retroactive actions and the unpredictability of administrative decisions, so the impact on Chinese investment is greater than what can be easily quantifiable by CFIUS enforcement. So that's the end of my presentation. Thank you.
Thank you very much, Ruming. That was terrific. Okay, and now, last but not least, I don't see Professor Matsushita on the screen, but I'm gonna assume he will join us. There he is. Okay, now Professor Matsushita will take over. Okay.
Okay.
Thank you.
Can you hear?
Yes.
Okay, good. I am Mitsuo Matsushita in Tokyo, Japan. And good afternoon, ladies and gentlemen. I would like to thank the organizers of this conference to invite me to this conference. Today, I'd like to discuss a little bit about the one legal aspect between the United States and China, and its relationship with the enterprises in third countries. Let me share the slide. I put the title "Trade Actions and Counter Actions: the Position of Third Countries." Now, what I'm going to talk about is the recent trend in the United States for the strengthening the export controls over some sensitive items destined to China and other countries, but especially China. And the Chinese counteractions to it, and positions of the enterprises in Japan and other countries that are caught between those two big powers. So this is the basic the subject I like to talk about. Now, the growing tensions between the U.S. and China. Well, this has been covered by Professor Sykes, so I just skip it generally, except to say that the U.S. has strengthened the export control in recent years. And China responded in various ways, but one of the notable the thing about it is that China enacted 3 laws recently. One is export control law, and the other one is anti-foreign sanctions law. And the third one is anti-extraterritorial application rule. This is the most common regulation. These laws give Chinese government the policy tools and justifications to deny and impose terms on foreign commercial transactions on the grounds of national security. Well, in other words, these laws are for the tit for tat retaliatory measures in relation to the United States. Now, the Japan dependency on foreign trade. Well, here, all I like to say is that Japanese companies are heavily dependent on the international the transactions with the United States and China. And I listed here the number of trade laws in the United States, but you know all of them, so I don't discuss it. Except to say that I focus on Export Control Act of 2018. Now, this law, I understand, applies extraterritorially. So in order to protect the U.S. national security, this law controls export and re-export and transfer of controlled items. And this law controls not only U.S. origin items, but also foreign-made items that incorporate more than the minimum amount of controlled United States content. And also, this law controls foreign-made items utilizing U.S. technology. So this means that this law applies extraterritorially in order to make sure that the foreign firms would not export control items from abroad to a prohibited destination. Now, so this is one type of situation I wanted to discuss. I'm going to discuss how it is going to work a little bit later. But now I'd like to discuss the recent legislation in China. Now, in response to the recent U.S. moves, China enacted several laws. Now, I talked about the export control law of China, anti-foreign sanctions law, and the anti-foreign extraterritorial application rule. I think this anti-foreign sanctions law and anti-foreign extraterritorial application rules, those two are more relevant. So I think I'm going to skip export control law and discuss the latter two law. Now, what are the foreign anti-foreign sanctions law that was enacted in June 2021? Now, if a foreign state or region imposes oppressive measures on the People's Republic of China, PRC has a right to take retaliatory countermeasures. This is Article 2. And then it says that the State Council lists up foreign individuals and organizations who directly or indirectly participate in the execution of such oppressive measures, including their subsidiaries and families and so on. And it also provides for countermeasures. And countermeasures could could include refusal to issue visa, seizure, and freeze of the properties in China, and so on. Now, now in Article 11, it says organizations and individuals in China must execute countermeasures as above stated. And organizations and individuals who violate above command shall be punished by law and prohibited from related activities. This is Article 11. And Article 12, this is important article, I think. It says any organization and individual shall not execute or cooperate with discriminatory measures of foreign states imposed against the citizens and organizations of the People's Republic of China. What is important about this article is that it says any organization and individual. It does not specify and say that the Chinese organization and Chinese individuals. The absence of this qualifier seems to indicate that this law applies to any company and any individual who implemented the measures against China. And those individuals and other firms will be subjected to Chinese penalty under this law. And also any organization or individual who did not carry out such countermeasures. This means that the China issues of the order not to cooperate with the foreign the discriminatory measures. So any organization or individual who did not carry out such countermeasures. In other words, any organization or individual who complied with foreign laws, which were directed against China, will be liable to legal action in China. So this is what it means, I think. And so as I said, one important aspect of this law is that the language used in this law, such as organization or individual, shall not execute or cooperate with discriminatory measures or foreign states. Those are the couched in very broad language, and then include the foreign companies and individuals like Japanese or the any other countries. But those are just a little bit of the anti-sanction law in China. And then a few words about anti-foreign extraterritorial application rule. This is not the law, I understand. This is the ministerial order issued by MOFCOM 2021. Now, it says in Article 2, this rule applies when a foreign law or other measures are applied extraterritorially. Well, this probably implies the US law and cause unreasonable restriction or prohibition on normal activities of Chinese citizens, corporate entities or other organizations in the economy and trade. Now, by the way, I have to warn you that this translation may not be correct because my Chinese is so poor that so it may have some kind of inaccuracies, but I hope that this conveys the general meaning of this law. Now, what's important about this test of undue extraterritorial application. This is Article 6. It says that it says what is the undue extraterritorial application of foreign law. Well, it says that it is contrary to the international law and the basic norms of international relations, and tend to injure the sovereignty of People's Republic of China. And also, if it affects the legitimate interest of Chinese citizens, and so this is the intent of this law. And in Article 7, this law says non-recognition and the non-enforcement of foreign law and other measures amounting to undue extraterritorial application. So when a foreign law or other measures are applied extraterritorially in undue manner, the State Council can promulgate a prohibition order that the law enforcement agency shall not recognize or enforce and comply with such foreign law or measures. So this is the Article 7 of this order. Now the next one is assistance to the party who incurs loss by not complying with prohibited foreign law. In other words, the Chinese law prohibits Chinese citizens and companies from complying with the foreign law, which is applied extraterritorially over to China. Then, if the Chinese companies or individuals have suffered loss because of not complying with foreign law, then Chinese government will compensate for it. So this is the intent of it. I think this is just about the brief summary of the Chinese law, which counter the U.S. move. Now, the result of it is this. I think I'm going to use this diagram to explain how it happened, how the things will happen. Now, here it's U.S. and U.S. government, the issues of the order under the Export Control Reform Act of 2018, and says to Japanese company A, you shall not export the product specified to China. So this is the U.S. government prohibition. This is number one stage. And then the Japanese company A, the issues directed to its subsidiary in China. Say that we cannot export the product to China anymore. So no export to China. Then the PRC government will impose penalty on the company A subsidiary in China, and then customer is going to bring up a suit against the subsidiary. Oh, this is what is going to happen. And the another situation is this. Now, people travel to China. The PRC government issues an order to company A that you have to stop exporting product to China, to the United States. Then the Japanese company A will direct the subsidiary to stop exporting the product to the United States. And then there is a contract between company A and the U.S. customer. And of course, U.S. customer will say that, oh, this is a breach of contract because you just didn't send out the product. So the company A, so the U.S. customer brings up a suit in the United States against company A. So in short, this is something like that, and this is the sort of thing that is likely to happen. And so this is the situation. Now, so what are remedies for the third country firms if they are caught between Chinese and the U.S. regulation? So this is becoming a more and more important issues in third countries like Japan, because many companies are so heavily dependent on the international trade with China and the United States. And in fact, as far as we in Japan are concerned, China is the biggest trade partner, and the U.S. is second biggest trade partner. And many companies have to trade with both China and U.S. Well, then those two sets of laws come in, and then they are in conflict with each other. Well, so this is a pretty difficult situation, actually. Now, but so I think there's not much that a third country firm can do when it is caught between U.S. and Chinese law. However, I would like to suggest a couple of things that those enterprises can do. So it depends on where the issues arise. In other words, is issue is arising in the United States or in China? if issues arises in the United States, like being sued by the U.S. companies in U.S. court. Well, this is U.S. law issues, and so I think you know better than I do. But I think I just mentioned a few things. If in damage and injunctive actions in U.S. court, maybe defense can be raised of the act of God. This is one thing. And if U.S. government comes in and try to impose the civil penalty or criminal penalty, then the foreign firm investigation could invoke the act of state doctrine or the sovereign compulsion doctrine, and they try to get the sentence, the decision in favor of that. And also the other thing is non-recognition and non-enforcement of Chinese government order. I think this will be a rare cases, but it could happen that the Chinese plaintiffs in Chinese civil court proceeding under anti-foreign sanctions law may request U.S. civil court to recognize and enforce the Chinese orders and seek for the attachment of property owned by Japanese companies if there is no property in China owned by the Japanese company. But then in such cases, the Japanese defendants could claim that the Chinese court order and our word cannot be recognized and enforced in the United States because to do so will be contrary to the U.S. policy, U.S. public policy. Well, what legal remedies is available in Chinese court is something that I cannot answer. So if you know any answers to it, I would appreciate them. If you tell me something about that aspect. But the non-legal remedies, well, this will be quite important. This is insurance. In Japan, there is something called a NEXI. NEXI is a Nippon Export and Investment Insurance. This is a government corporation. They can provide insurance for losses due to unexpected profits in export trade and investment. If China invokes anti-foreign sanctions law and anti-extraterritorial application rule in China, this will be regarded as a type of country risk surrounding international trade. And so this sort of thing can be covered by the insurance provided by this NEXI. And other the public and private banks in Japan can provide similar insurance to firms engaged in export and investment, export trading and investment. Now, in the United States, I understand that the Exim Bank can provide a similar foreign trade and investment insurance. Now, the other thing I'd like to discuss is that if convergence is accomplished between the national security laws of the United States and Japan, it will ease tensions between two countries with regard to enforcement of those laws, because then both both countries control and embargo the same or similar items. And the firms and individuals in both countries are controlled by the similar rules. So this will ease the tension. And in fact, there are many similarities between the U.S. national security laws and Japanese counterparts. Japanese counterpart is called the Foreign Exchange and Foreign Trade Law of 1949 as amended. And in fact, there will be a legislation in Japan which will be coming in a couple of days from now, which cover the national security issues quite extensively. And so in this way, both U.S. and Japanese Japanese companies will be will be under the two sets of laws that are rather similar to each other. So this is one thing I like to mention. And in fact, there are cases where Japanese firms exported prohibited items to designated areas and were punished both in the United States and Japan. So the one is a Toshiba machinery case. This is 1988. This is a Kaufman case, and Nippon Aviation Electronics case. This is 1996. In both cases, the Japanese companies engaged in the export to Soviet Union. In the case of Toshiba machinery, and in the case of aviation electronics case, the Japanese company exported the product to Iran. In violation of the Kaufman agreement, and also a U.S. law and Japanese law, and both of them, both of those two companies were punished in Japan and United States. So, in this sense, the chances of conflicts of regulation between U.S. and Japan, which relate to national security, are not great. And the prospect is that there will be more and more a coordinated activities between Japan as regards the national security laws. So conflict will not be so great in this area. Conflicts and tensions between Chinese national law and those of U.S. and Japan are more difficult to resolve. And I don't know how to resolve this issue. This, I think, is essentially not the legal problem. This is a political problem, and so it has to be left to the political negotiations by the leaders of those countries. Well, this is all I have to say. So thank you very much, for listening.
Thank you very much, Professor Matsushita. Okay, I would like to now invite the audience to type in any questions you would like in the Q&A section. And we have all the panelists back with us. And while we're waiting for the questions, I'm going to have to rely on one of my other excellent student helpers to see if there are any questions in the chat line. I don't see any personally myself right now, but I have a couple that I would like, because you've all raised some really fascinating issues. In the past few years, and all of you talked about this, trade sanctions as well as greater approvals for investment, almost sort of you mentioned countervailing duties, WTO litigation. All of these things have been continuously, if you will, dogging and plaguing the US-China relations and trade area. And you've all mentioned that these things are not always effective. So I was just wondering if the panelists have ideas or views about how we could do better, perhaps, what trade and investment measures might work to actually facilitate this rather than creating issues. And maybe I am the question is slightly leading, but so. Anyone want to start? Feel free to just chime in.
Well, I just kind of reiterate a point or two I made earlier, that I think the US has been trying to deal with China sort of unilaterally with most of its initiatives, Section 301 tariffs, we've gotten more aggressive on investment review and so on. And just as we're seeing with sanctions and other contexts like the war in Ukraine, there's an awful lot of leakage in a world where nations try to go after things unilaterally. So I think to create a greater chance of success in persuading China to change its policies, the best approach is to try and generate multilateral pressure. And it's hard to do that within the WTO system itself, because it's a consensus-based organization. So China can essentially stop the WTO from doing anything that China doesn't want it to do. And so the alternative is sort of informal groups of countries. I mean, the thought behind the Trans-Pacific Partnership initially was that that would create a multilateral group that would have some leverage over China because it would include Japan and lots of Pacific Rim countries and so on. And that's, I'm not sure that will work, but it's likely to be more successful than the kind of unilateral approach that the United States has been pursuing. We just don't have enough leverage as things are. And the leverage is shrinking over time as China gets bigger and bigger and is less and less dependent on keeping us pleased. So that's my one thought for what might be more successful with China is to generate multilateral leverage rather than going unilaterally.
Okay, thank you. Anyone else? Any other panelists? I sort of had a little bit. Oh, go ahead, Professor Matsushita. Did you want to say
Yeah,
something?
well, I just wanted to say that I am not in a position to criticize how U.S. law is enforced and employed and so on. But I just mentioned a few things about the WTO aspect of it. I think that the WTO has not been so effective in the controlling the subsidies, especially in China. And Professor Sykes mentions about one of the very bad cases on the subsidies. So that's that issue of how to interpret the public body, the word public body. And in my opinion, that's the decision of the affairs body on the public body may have been a little bit too narrow. It made a distinction between the government and public body, and then said that the public body has to be something different, and so on. And in my opinion, that may have been a little bit too narrow and didn't exactly match the reality of international trade. And also the Chinese, state-owned enterprises, those are a very big problem in many ways, because the activities and behaviors of state-owned enterprises are quite different from the private enterprises. And then sometimes that's quite disruptive of the market order. And so the one question is what to do with it. Now, there is no rule on state-owned enterprises in the except for the GATT Article 17. What rule do we apply to state-owned enterprise? Well, there is one section in the in TPP about state-owned enterprises. This is the chapter 17. Now, I looked at chapter 17, and chapter 17 seems to have also a problem because the chapter 17 is almost like a prohibition of the state-owned enterprises. And this is an attempt to convert state-owned enterprises into private enterprises. And so this is a little bit too idealistic, and so it will not work so much. So I think one important issue in the future is to come up with some kind of rules and on the conduct of the state-owned enterprise. I don't know where it is going to happen, and I think the amendment or the introduction of new rules in WTO will be very difficult. And so probably some kind of informal guidelines by OECD or the UNCTAD or something like that, maybe one of the things that we can think about.
Thank you. Ms. Liu, did you want to say something or?
Yeah, from my perspective, because I'm more, on the practice side, I'm more concerned about vast majority of, people who are making investment or just want to make profits, like honor investment. So I think from their perspective, what I can feel is if the lawmaking or the rulemaking can be more predictable and, and the stable of the policy is the key for, boosting the economy whole and, make a healthy relationship. For example, executive orders could, come out at very emergency situation. However, in some circumstances might not be the best way, which if you look back and retroactively, it's caused a lot of shock to normal investors and will cause unnecessary fear, which curb a lot of benign transactions.
Thank you. I actually like to take this sort of taking a lead from Professor Sykes about his reference to Ukraine and sanctions. As we all know, the US, the West, and EU, many countries have taken strong sanctions against Russia. China and some other countries in Asia have not fallen in with those sanctions. They have either maintained status quo or in some cases in Southeast Asia, increased their purchases of Russian oil because it's right now cheaper. And I was just wondering, particularly with respect to China, in terms of the long run, in terms of their participation in the international trade community, this sitting on the sidelines and trying to be somewhat neutral, I was just wondering if you all can opine on the pros and cons of this strategy. Too political. Says, maybe I can rephrase the question a little bit too. And this particularly, I think for Ruming, I'm going to put you on the spot here a little bit. I think given the sanctions against Russia, China has really taken measures to be self-sufficient. That's something that they've done for the last few decades because they were always afraid of being left without technology, without the ability to sustain themselves. And given the sanctions, they sort of know. And today, I think Secretary Yellen already said that if China does anything vis-a-vis Taiwan, there will be sanctions. So this has made it, I think, even more urgent for them to do so. So I was wondering if you think China is going to prepare or they're just going to go their own way because they are becoming an incredible economic power. Thoughts? I'm getting there. Getting a 5-minute warning. Yeah.
Yeah, from my understanding, I doubt China going to pick sides in in this situation. The reason is that China Russia has been a long-term relationship, and they were. It's very political, but just my personal understanding is that it's very hard for China to take sides. Unless something extreme happens. So I think unless China indeed are going to initiate the war against, Taiwan, got sanctioned. But in this situation, I think there's a lot of shock to the Chinese government and officers. Right. But still, it's not enough cause for Chinese government to take positions.
I guess I asked this question in part because I was a little bit surprised by China's actions, not in the sense of taking a neutral position, but actually moving closer to Russia. China, as you know, had a very strong friendship with the Soviet Union in the 50s and 60s, but the Soviet essentially pulled out and kind of left China, particularly the industrial sector, on its own. And there was a sense of strong abandonment. And I would have thought that the Chinese would kind of remember that and be cautious about re-establishing a strong relationship with China. So that's part of the reason I asked this. Is this a temporary strategic situation, or is it a long-term trade policy or investment policy? I don't think investment is that issue here so much, but trade certainly is. So, okay. Well, we are, I think, almost at the time. I'm sorry, I can't find the clock on my thing, but yes, we have about 2 more minutes. So any closing remarks by the panelists? Well, I do want to thank you all very much for your attendance, and I want to thank the audience for staying with us. I know it's a long-term time to be on Zoom and watching, and so I thank you all very much for your participation. Bye-bye.
Bye-bye.
Thank you, Professor Han, Professor Sykes, Professor Matsushita, and Ruming for your contributions to such a wonderful discussion. So this concludes our second panel, and we will now go on a 10-minute break, and our final panel will start around 4:20 p.m.
Can you hear me?
Yes, I can.
Professor
Can you hear me?
Jimenez,
Wonderful, thank you.
So hi, everyone. Welcome back. We will start our last panel on human rights now. Please also remember that you can receive up to 3.75 hours of MCLE credit. Please fill out the Google form, which we will provide in the chat box. You only have to fill out the form once. So our final panel will be on human rights, and it's moderated by Professor Philip Jimenez from Santa Clara Law. Professor Jimenez specializes in law relating to East Asian cultures. He was also a moderator last year at the Symposium for International Arbitration. So we are so excited to welcome him back again this year.
Thank you. Excuse me. Thank you very much. And thanks once again to this wonderful board of editors of the Santa Clara International Law Journal for organizing this wonderful symposium and for giving me the honor of introducing our speakers on this panel. And what a great honor it is for me to introduce such bright, committed, and accomplished lawyers and scholars. We have limited time today, and so I believe that resumes of these speakers have been published. So what I'm going to do is simply introduce and highlight a couple of their accomplishments as we go through this. Our first speaker on this panel will be Professor Martin Flaherty, who is Leitner Family Professor of Human Rights Law and founding co-director of the Leitner Center for International Law and Justice at Fordham Law School, as well as a longtime visitor at the School of Public and International Affairs at Princeton. Professor Flaherty has lectured widely abroad, has taught at China University of Political Science and Law and the National Judges College in Beijing. He serves as legal consultant to the 6th Committee of the United Nations General Assembly and participated in a number of human rights missions, including to Kenya, Malaysia, Northern Ireland, Mexico, and Romania. Professor Flaherty's publications focus on international law and history, foreign affairs, and international human rights, including his most recent book, Restoring the Global Judiciary: Why the Supreme Court Should Rule on Foreign Affairs. A lot of controversy there. He will today present, first of all, on the ongoing situation in Xinjiang, the treatment of the Uyghur people and international criminal law, on Hong Kong and international human rights law, and on the ongoing assaults on lawyers in the People's Republic of China by presenting a representative case. Professor Flaherty, wonderful to see you. Shall we get on with it? Thank you.
Yes, we shall. Thank you, Professor Jimenez. It's an honor to be introduced by you, and it's an honor to be participating, even if virtually, at Santa Clara. I've been to Santa Clara several times. One of my oldest, dearest friends is your colleague, Professor David Sloss, so who is one of my absolute favorite fellow academicians. So it's a real treat to be here. So I am assuming I can, yes, looks like I can share. So why don't I get to my slides for the talk here. And can you see that? Can everybody see the slides?
Looks fine. Good.
Okay, so the reason the template is Princeton rather than Fordham is actually most of my teaching, and for that matter, human rights advocacy with regard to China these days is from my base at Princeton as opposed to Fordham, although Fordham we do have various China initiatives as well. And these are slides adapted from a course I teach on Chinese foreign affairs, but I have readapted it for an audience that is sophisticated about law. As Professor Jimenez said, this is what I'm intending to cover. But by way of preface, let me just start by talking about and comparing and contrasting what's going on in China with the event that's really dominating the headlines, which is the Russian invasion of Ukraine and some of the international legal repercussions. And I do that not just because, despite my name, I'm half Ukrainian. So as we know, there is the Russian invasion of Ukraine, blatant violation of Article 2.4 of the UN Charter, war crimes being committed, and also investigation already being undertaken in the International Criminal Court. What is interesting with regard to the international reaction, at least to me, is that despite the frustrations of the veto of the Permanent Five, Russia in particular, on the Security Council, one thing that's interesting to me is not how little, but how well international law has operated. And I say that broadly to include human rights law, laws of war, humanitarian law, and international criminal law, at least prospectively. And what do I mean by that? Well, two developments. One is that as a result of the invasion, 140, I think 141 states in the General Assembly actually voted to condemn the invasion as a violation of international law. That is rare. Even more rare is the fact that just this week, the General Assembly voted to remove Russia, the Russian Federation, from the Human Rights Council, which, as far as I know, is unprecedented for one of the Permanent Five members of the UN Security Council to be removed from the Human Rights Council. So that would seem to be, or one could make an argument that illustrates that international law, at least on some level, is working. Now, how does that relate to China? And then that will prompt me to get into my remarks. Well, I think it's a combination of things. One is just how dramatic and blatant Russia's human rights violations and international law violations are, and the fact that even though Russia is powerful, although not as powerful as Putin thought it was, and even though it's a member of the Permanent Five, its economic, military, diplomatic, soft power just doesn't compare to China. And that, I think, helps explain why the objections of many people I see on social media are unaddressed. And what are those objections? Well, why is China still on the Human Rights Council? Why has China not been condemned by the General Assembly in the same manner Russia is? And so I think even though Ukraine is the focus of the international press, we shouldn't remove our gaze from China and what's going on there. So let me begin by covering the first of four things I want to talk about. The first is basically why things have gotten significantly and palpably worse with regard to human rights in China under Xi Jinping. Second, as Professor Jimenez said, I want to talk about Xinjiang, in one sense moving in. I then want to talk about recent developments in Hong Kong. And then finally, focus on an area within mainland China itself, which is an issue I have worked on for quite some time. And that is the plight of Weiquan, or otherwise known as human rights or impact lawyers in China. So let me start with first talking about Xi Jinping and Xi Jinping's China. And some of these slides I'm going to skip over very quickly because they're more adapted to this other course. But before I go into any of this, there is a current raging debate among China specialists in the international affairs community. And the debate concerns whether the 40-year period of engagement by the United States and the West trying to build up a China that has rule of law domestically and is a responsible stakeholder in the international arena has, if not failed, certainly has not gone the way as anticipated. In 1979, 1980, Deng Xiaoping consolidated his power as the most powerful leader in China, succeeding Mao. But unlike Mao, Deng Xiaoping opened up the country and committed it to engagement with the West, including the building up of the rule of law. And the hope from Western policymakers was that that indeed would start to look like the West itself, that there would be, if not multi-party democracy in China, there would be at least some semblance of what in the West would be identified as rule of law, as well as a modicum of respect for international definitions of human rights. And for quite a while, it looked like there was reason to be optimistic. Things started to plateau from the point of view of most China hands, not much after the millennia. I'll return to this more specifically when I deal with Chinese lawyers, through the 2008 Olympics. But after that, in the latter stages of Hu Jintao's administration, there was a palpable backsliding with regard to human rights. So no longer a lack of progress, but a palpable backsliding in human rights manifested in several ways. But it really wasn't until 2012, with the ascension and consolidation of power of Xi Jinping, that things really started to fall off the table. Now, who is Xi Jinping? I'm not going to say too much about him. He is actually the son of a prominent Communist Party leader who, ironically, was a victim of the Cultural Revolution, of the excesses of the party. But the main thing to keep in mind about him is that when his predecessor, Hu Jintao, was up for essentially stepping down from power, Xi Jinping was the first among equals to ascend to his succession. Now, early on, there was optimism with regard to Xi Jinping, and it looked like at the very worst, he would carry on what previously had been seen as an era of collective leadership. After Deng Xiaoping, the successive leadership in China adopted a model of kind of gray, not very charismatic collective leadership. And it looked like Xi Jinping would continue that tradition and simply be the first among 7 or 8 equals in the Standing Committee of the Politburo, which was the apex of power in the Communist Party. But very quickly, things started to look different. Xi took the 3 major posts in China all at once, which really hadn't been done since Mao. He became the most important thing, the General Secretary of the Chinese Communist Party, which is actually above the government, chair of the Military Commission, which essentially meant he was in charge of the People's Liberation Army, and then became the president of the People's Republic of China a year later. And at this time, unlike his immediate predecessors, he started purging largely through trumped up charges. Well, actually, the charges were true, but through targeted trials, some of his main rivals, and I won't go into the details. But even then, it looked like he would use this increasingly centralized power towards reform ends. In particular, he instituted an anti-corruption campaign in the Chinese Communist Party, and more positively, famously talked about the Chinese dream as kind of the Chinese analog to the American dream. And one of the other touches he had was a touch of the common man. This photograph you have was very famous in China. It made an enormous stir because he went into a simple dumpling shop in Chinese baozi and just sat down with common folk and dined with them. He made sure this was widely publicized in the Chinese media, but it made him seem as a leader with the most common touch since Mao. Well, unfortunately, the parallels with Mao started cutting the other way. First was as that the dark side of that visit to the dumpling house was that Xi, more than almost any other Chinese leader, started cultivating an individual cult of personality. No longer was it, as it had been for the previous 20 years, this notion of kind of gray collective leadership. But Xi, especially after having purged important rivals, started to promote his own image and promote his own story in a way that hadn't been seen even during the time of Deng Xiaoping, and really which hadn't been seen since the time of Mao Zedong himself. Another sign of his increasing consolidation of power, and this is something that got a lot of publicity in the West, if anything, perhaps too much publicity in the West. But in 2017, what had been term limits on the presidency in China, which was 2 5-year terms, was eliminated. And that meant that theoretically, Xi could become president for life. Now that's important, but that's not as important as the fact that he was already chair of the party, and the Chinese Communist Party is far more important than the Chinese government, in no small part because it runs the government. And he was always able to stay as chair of the party as long as he wanted. Still, the symbolism of him no longer having to step down, and he would have to step down in 2022 as president if these restraints hadn't been removed, showed a consolidation of power that had not been seen for decades. Another thing that was troubling to observers and to people within China was the issuance of a paper by the party talking about legal reform in 2014, but that stressed and made clear that the party, not to be blunt about it, not to put too fine a point on it, was above the law, that the party was not constrained by the laws of the government. And at the end of the day, what the party said went. Then we see concomitant with that various policies that ever more dramatically started to threaten the enjoyment of fundamental rights. One was the strengthening of what's known as the Great Firewall, the sealing off of the Chinese internet from access to the world abroad. Second was renewed state control of the economy. China is not really communist. In fact, it's not really Marxist. If anything, the Chinese economy is best characterized economically as an example of crony capitalism, not incredibly different from Russia, but certainly more productive. So China is capitalist with that twist of cronyism and corruption thrown in. It is, however, Leninist. That gets back to my point about the party maintaining an iron grip on all forms of power within China. That in turn, and to ensure that iron grip, an increased crackdown on dissidents and in particular human rights lawyers occurred, which I'll talk about, as well as almost unprecedented actions in Xinjiang, as well as shockingly dramatic incidents or changes of policy in Hong Kong. So it is those three things that I am going to deal with in the balance of my remarks in reverse order. And I am just I am under the understanding that our other speaker couldn't make it, so I'm going to be extending my remarks a bit. If that is wrong, somebody please let me know. I'm not sure I have access to the chat while I am sharing the slides. Okay, and that's the foreign policy aspect. So let's talk about Xinjiang. What is Xinjiang? Where is Xinjiang? Xinjiang is, as you can see on this map, it's technically today called the Xinjiang Autonomous Region. It is the province of China that is, oh, sorry, let me just check the chat, which I now can see. Just want to make sure. Okay. It is the province on the northwestern corner of China, bordering Central Asia. It was one of the thoroughfares for the traditional Silk Road that you could see on this map. Now, there are disputes about how historically Chinese it is. Long story short, not unlike some other parts of China, like Tibet and Taiwan, even though there are Chinese historians and Chinese politicians who might dispute that, when we're talking about Xinjiang and, as you can see below it, Tibet and even arguably Taiwan, what we're talking about are regions on the periphery of China that were not always part of China, or at least not as part of China as long as other parts. In particular, these parts of China were part of China at the apex of the Qing Empire in the 18th century. And in one sense, it's clear that one of Xi Jinping's goals, not unlike Putin's goal with regard to Ukraine and other nations that were part of the former Soviet Union, part of Xi Jinping's goal is to restore China, to reintegrate China at its historic height when it comes to geography. And that historic height came during the Qing dynasty, where the Qing emperor conquered what is now Xinjiang. There are those, especially those in Xinjiang, who view things differently and don't even use the term Xinjiang to characterize the region. For them, it's East Turkestan. And indeed, for a time during the chaos in Chinese history in the 1930s, and then immediately after World War II, East Turkestan did break away from China and declared briefly independent republics. And in fact, if you see protests, which I used to see all the time because I live right near the UN with regard to Xinjiang, you would see this light blue version of the Turkish flag, which was the flag of the Second East Turkestan Republic. Now, that flag brings up two critical points about Xinjiang. One is that ethnically, at least even still, the majority of people in Xinjiang are not Han Chinese, but they are Uyghurs, which is a Turkic ethnic minority in Xinjiang. The second crucial fact is that the Uyghurs are overwhelmingly Muslim. So we are talking about a group in this province that both ethnically and religiously is different from mainland Han Chinese. And therein lies much of the problem. So, and that was only a problem from the point of view of the leadership in Beijing. Now, part of the strategy, even far before Xi Jinping, to ensure that these far-flung provinces stay loyal and integrated to China, was something that some scholars call Sinification. I call it Hanification because I do think there's an ethnic component to it. And that essentially is the idea of moving Han Chinese into the province, to dilute the Uyghur population, to have loyal Chinese in a province that whose loyalty, at least the leadership in Beijing, can't completely count on. Same process with regard to Tibet. In fact, before current events with regard to Xinjiang, Tibet used to get far more publicity in the 80s and 90s. And indeed, what happened in the 90s, which was this conscious effort to have Han Chinese migrate into Xinjiang, largely went under the radar, even of human rights advocates. So that's what's occurring in the 1990s. But what happens is that overall policy of trying to Hanify Xinjiang dovetails or combines with post 9/11 war on terror, fear of jihadi Islam. And whether, and to some extent, there, as I'm going to say, there is some reason for the leadership in Beijing to be concerned about what's going on in Xinjiang. But largely, at least in my view, the further crackdown on Xinjiang in the name of combating Islamic terrorism is more opportunistic than anything else. Well, what is the kind of basis, at least from officialdom, for taking a stronger set of policies in Xinjiang? There were riots in Urumqi, which is the capital of Xinjiang. Largely, those riots were a function of the second-class citizenship to which Uyghurs were being placed. The unemployment rate for Uyghurs was over twice what it was for Han Chinese, and that resentment bubbled up, but it bubbled up in a violent way. And then even before that and after that, there were periodic terrorist incidents, largely things like knife-wielding Uyghurs in train stations, killing a number of Han Chinese. Nothing like what we saw in 9/11, but still, significant. You see a woman mourning after the death of her husband in one of these knife-wielding terrorist attacks. But for those who thought, rightly or wrongly, that the US response to 9/11 was disproportionate, that observation would apply with even greater validity with regard to what has happened and is happening in Xinjiang. And that decision to crack down on Xinjiang came from the top, Xi himself, and also was manifested in the appointment of this official there, Chen Changguo, who previously had made a career of putting down Tibet. And who are some of the victims? I want to personalize this because I'm going to talk more generally. The woman on the left is the daughter of a very moderate Uyghur professor based in Beijing, who has been in detention really since 2014. She would have been too. They were both about to get on a plane for him to teach at the University of Indiana. But Ilham Tohti was pulled off the plane, put into detention. His daughter, who didn't speak English, rushed onto the plane at her father's insistence. And she has been in the US ever since. And I urge you to get on her Twitter account because she's become a pro-Uyghur human rights advocate. Likewise, Rehan Assad, who I was just emailing the other day. Rehan is a graduate of Harvard Law School. She was a corporate lawyer, originally from Xinjiang. But 6 years ago, her brother, who had been a famous athlete in Xinjiang, was put into a re-education camp. And ever since, Rehan has become a leading human rights advocate for the Uyghurs in general and with regard to her brother in particular. So in thumbnail, what are some of the policies that Xi Jinping's administration has wrought? Well, most famously or infamously, it is the re-education, a nice word for what really are concentration camps. They're not death camps, but they are concentration camps in Xinjiang. And estimates run that 1 to 1.5 million Uyghur men have been placed in these re-education camps for years. And these are some rare pictures of those camps. But it's not just the camps. There is more general repression. This is known as cultural genocide, which is not a legal term, but what it refers to is the attempt to stamp out Islam and to stamp out the Uyghurs' distinctive culture. So there have been the destruction of mosques. There's been the ban on Muslim practices, including Muslim dress, men wearing beards, forcing people to eat during Ramadan, and sort of something that still shocks me, bounties for Han Chinese men to marry Uyghur women to continue this idea of diluting the population. Even outside the camps, Xinjiang itself has essentially become the cutting edge of a dystopian surveillance state. There are cameras and facial recognition devices all over Xinjiang, including using artificial intelligence, as well as biometric data collection, as well as Communist Party cadres actually moving in with Uyghur families to monitor that they are not lapsing back into Islam or Uyghur mores. Now, very quickly, and somebody let me know if our guest speaker is coming, but if she's not coming, I'll continue to do the more extended version. But if I don't hear anything, I'll keep going as I'm going. The two big questions in international law is this genocide or is this crimes against humanity? Well, what is on the screen is the definition of genocide in the Statute of Rome, which creates the ICC. Now, China is not a state party, but this definition would encompass customary international law applicable to China. And here's the thing. Clearly, some of the acts necessary to establish genocide are occurring, including B, causing serious bodily or mental harm to members of a specific ethnic, national, or religious group, and imposing measures intending to prevent births within that group, and also forcibly transferring Uyghur children to Han families. All of those are going on. So why isn't that genocide if they're part of the list? The problem is what's bolded, because for genocide, those acts have to be committed with a specific intent to destroy that particular group, in whole or in part. And basically, the argument has to be that the Chinese authorities are not trying to transform the Uyghurs into Han Chinese, but what they are trying to do is actually destroy, in whole or in part, the Uyghur population. That is a closer call. Human Rights Watch has not gone that far. The United States government has. There are arguments either way. I tend to lean towards the conclusion of the US government, but I acknowledge that it's not an easy call. What is an easy call is crimes against humanity. Crimes against humanity doesn't require an intent requirement. What is crimes against humanity? It is acts committed as part of a widespread or systematic attack directed against the civilian population. And you could see the acts. They are murder, that's not really happening. Extermination, not in the kind of obvious sense. Enslavement, not really, although we could debate that, but certainly forced labor, forced transfer of the population. There is forced labor, which would be under an expanded definition of enslavement. Imprisonment, obviously. Torture is taking place within those camps. It goes on and on. It's an easy call to say that there are crimes against humanity. So if we have witnessed crimes against humanity against the civilian population in Ukraine, and that has prompted an international revulsion, one could easily make the argument that the same degree of international revulsion should be taking place based on the scope and scale of what's going on in Xinjiang. All right, let me talk about the other two topics. Hong Kong and Chinese lawyers. So Hong Kong, this is a map of Hong Kong. This slide is basically how the British got Hong Kong. The important thing is when the British seized Hong Kong as a matter of a war in which the British wanted to essentially impose opium consumption on China. Hong Kong was a small fishing village. But ultimately, Hong Kong became an economic powerhouse in the mid to late 20th century. The problem was that body here called the New Territories was not part of Hong Kong that was ceded to the British in perpetuity, but it was part of a 99-year lease that was coming up in 1997. And long story short, that led to negotiations between Deng Xiaoping and Margaret Thatcher to turn over all of Hong Kong back to British sovereignty by 1997, by the time the lease expired. But there was going to be the terms of that handover were memorialized in something called the Sino-British Joint Declaration that Thatcher and Deng Xiaoping signed in 1984. What is that? Well, it's nothing short of a bilateral treaty under the Vienna Convention on the Law of Treaties. It is a treaty between the United Kingdom and China. And basically what this treaty was meant to do was to institute an idea of Deng Xiaoping, which was that for 50 years, Hong Kong would retain a high degree of autonomy from governance by the mainland. It was something that Deng Xiaoping coined as one country, two systems. And one of the ideas about this was that the world would see how well China was treating Hong Kong, and that the Taiwanese would view that as a model for them to re-enter China. Taiwanese never bought that, but that was the hope on the part of Beijing. And even without Taiwan, Hong Kong was useful to Beijing because it had a superb legal system, largely, a British legal system that was perfect to make Hong Kong a center of direct investment into China. So what did the Basic Law guarantee? It guaranteed a legislature that was only 1/3 directly elected, but a legislature nonetheless. A chief executive who would eventually be elected by popular vote, although that would be delayed for 15 or more years under the Basic Law. Most importantly, a separate common law judicial system that guaranteed rights. And indeed, the Basic Law incorporated into domestic Hong Kong law the International Covenant on Civil and Political Rights, which meant that not China, but the Hong Kong government had to abide by the ICCPR, which, for complex reasons, it still has to today. The Human Rights Committee of the ICCPR still has jurisdiction over Hong Kong, though not China, because China is not a state party to the ICCPR. Well, the system worked pretty well, actually. I spent a lot of time in Hong Kong during these years, and one country system, two systems, despite a lot of skepticism, worked. There were certain controversies, which for lack of time, I won't mention, other than there was a lack of the democratization that was promised under the Basic Law. And that started to lead ultimately to trouble, including as well as demographic changes, like a generation that grew up under the one country, two systems formula. The trouble began with peaceful protests in a series of demonstrations that was originally called Occupy Hong Kong Central, which is part of Hong Kong, very much aping the Occupy Wall Street demonstrations. And Part of what the protests were about was economic inequality in Hong Kong, but a large part of what the demonstrations were about was the lack of democratization, especially with regard to choosing the chief executive. Eventually, the umbrella movement dispersed. Why was it called the umbrella movement? Because when these very, very, very peaceful protesters were targeted with tear gas, they used umbrellas to protect themselves, and that became the symbol. One thing that's not on my slide but should be is things were quiet until 2019. In 2019, another set of demonstrations began of an even larger scale. Why? Because the Hong Kong government introduced an extradition law into Hong Kong law. Previously, if you committed a crime in China, escaped to Hong Kong, you could not be extradited back to China. That was part of the original setup of one country, two systems. And it would have remained, it would have been left to Hong Kong to the Hong Kong administration, which was very cozy with Beijing, introduced such a law. It produced, right before COVID, incredible protests. Hong Kong's a city of about 6 million. Estimates are about 1 million people took to the streets, okay? And those kinds of protests very much unnerved Beijing. Now, the law was eventually withdrawn, but the problem was nothing else was done to address some of the legitimate concerns that these 99.9% peaceful protesters were advocating for, particularly democratization. Ultimately, Beijing's response came down like a sledgehammer at the beginning of 2021. And that sledgehammer, which is one that is affecting Hong Kong even as we speak, is the national security law. The national security law is essentially if you want to think of it this way, a federal statute enacted by Beijing that covers Hong Kong. And if you think of the Hong Kong Basic Law as a state constitution, the national security law overrides it to the extent there are any differences. And there are many differences because the national security law, without too much exaggeration, goes a long way to eliminate one country, two systems with regard to the rule of law and certainly the common law system and the protection of rights. What are principal features of the national security law? One is the 4 principal offenses are drawn incredibly broadly. In US legal terms, they'd be seen as overbroad. The offenses are secession, subversion, terrorism, and collusion with foreign entities. And even now they are being used against people who do things that wouldn't be considered any of those things by a conventional definition. One of the first prosecutions was a guy who drove into, I think even mistakenly, his scooter slid into a group of policemen, but he had a banner that promoted Hong Kong independence and autonomy. That was enough to threaten national security under this law. And that person has been convicted, tried, and I think sentenced to 9 years. There are also procedural problems with the basic law. Only judges, Hong Kong judges who are vetted by the Hong Kong government can hear cases with regard to the national security law. Not any judge, but only judges pre-approved by the executive. And if that's not enough of a procedural safeguard, trials for violation of the national security law at the executive's discretion can also just be transferred over to courts in China, in the mainland. And courts in China resemble nothing like the courts in Hong Kong in terms of anything remotely looking like judicial independence or due process. And so what have been the effects of the basic law? Well, a shutting down of NGOs in Hong Kong, almost all of them have either left or been shut down. A shutting down of political parties, opposition parties in Hong Kong. A shutting down of media. For example, Apple Daily was the largest Chinese language newspaper in Hong Kong, but it had an opposition, pro-autonomy lean. It was shut down. And its editor, Jimmy Lai, was since prosecuted under the British colonial laws that still remain in Hong Kong, and he's in jail. A troubling development was police impunity, not unlike some of what you see in the United States with regard to police response in some localities with regard to the Black Lives Matter movement. Police going and beating protesters, police who were dressed like SWAT teams, which had not been the case 20 years ago in Hong Kong. The exile of leading Hong Kong democracy advocates, like the younger Nathan Law and another colleague of mine who's now visiting at Harvard, Dennis Kwok, who is a respected barrister who had represented the barrister constituency in the legislature. And convictions of many of the prominent dissidents in Hong Kong under both pre-NSL British colonial laws as well as the NSL. So Hong Kong is it's almost night and day when it comes to civil society, rule of law, free speech in Hong Kong. And for those of us who are many who loved Hong Kong, because it was really a tremendous city, that's really a tragedy. Okay, final thing. And I hope I'm gauging the time correctly, flying solo here, is the role of lawyers. Now, what's this self-aggrandizing picture? One thing I do at Princeton is we have a group of juniors who do projects about promoting the rule of law in China, and we give ultimately presentations at the State Department and White House. So this is one of those groups. This is something I've been doing for 20 years, and 20 years ago, it was a hopeful task. Now, what this task force is doing primarily is trying to defend academic freedom in the United States from encroachments by China. So there was a time when this task force would be working with human rights lawyers in China. Now, that cause has almost become lost. Well, what is the story of legal engagement in China? Again, it's a function of Deng Xiaoping's regime. Deng Xiaoping wanted to create a genuine legal system in China for two reasons. One was to encourage foreign direct investment. The other was to ensure that the chaos of the Cultural Revolution, of which he was a victim, would not recur. And so lawyers started flocking into China. This is one of my mentors, Jerry Cohen, currently at NYU, who is teaching, involved in legal exchanges in China. And that's what brought me to China. I was teaching US constitutional law in China in the late 90s, and US professors had rock star status in China. Nothing like the way we're treated here in the United States. However, to telescope this story, what is a funny thing about the rule of law, especially from the point of view of a government? It can be a double-edged sword. So once you create a legal system, and when I say create, there were virtually no lawyers in China in 1979. Today, there are about 400,000. In 1979, there were no law schools, really. Today, there are over 300. So that's creating a legal system. But what is it about a legal system, especially a legal system with so much Western influence? People figure out that it can be used against the government as well as on behalf of the government. And these are three victims. Gao Zhisheng was a commercial lawyer who was listed as one of the 5 most prominent lawyers in China in 2005. But as a pro bono matter, he made the mistake of representing very unpopular clients, including members of Falun Gong. Gao Zhisheng, since 2006, 2007, has either been incarcerated or disappeared or both ever since. The person in the middle is a friend of mine, Tung Biao. He was a lecturer at the university I lectured at. He was a constitutional lawyer and professor. And he actually had a joint program with Yale Law School about promoting constitutional law in China. That around the time of the Olympics, his program was shut down. He was arrested twice and tortured, and he has since fled to the United States and visited places like Harvard, Yale, and right now he's at the University of Chicago. And without taking more time, Lu Jun, another friend of mine, friend with a similar story. As bad as things just got even worse. Really 2 points where the plight of lawyers got worse in China, at least those lawyers who represented clients who were unpopular from the point of view of the government. The first era where there was real widespread persecution of those kinds of lawyers was coincident with the Arab Spring. And that was no coincidence. It was seen, the leadership in China saw that lawyers were involved in those kinds of resistance movement. They wanted to nip it in the bud in China. And so several dozen leading lawyers were arrested, disappeared, tortured, beaten up, disbarred, and several of their law firms were closed down. Things got even worse on July 9th, 2015, known among Chinese rights lawyers as the 709 crackdown. Numbers that are banned on the Chinese internet are 6-4 or 6489. That's the Tiananmen Square massacre. Another set of numbers that are banned are 709. Why? 300 lawyers, really in 1 or 2 days, were disappeared, tortured, arrested, disbarred. And this woman, Wang was one of the first and became sort of the poster person for that crackdown. Wang is a commercial lawyer, but she took as a pro bono matter cases against principals and administrators in Chinese high schools who she said engaged in sexual assault against teenage girls. That was permitted for a while, but once Deng Xiaoping started to clamp down, because she was going against ultimately government officials, these high school administrators, she was arrested, okay, and had to make a public coerced confession on TV. And that crackdown has, on a lower boil way, continued ever since. So for lawyers who do this kind of work in China, things remain very grim. And it is, 10 years ago, 15 years ago, we've gone from a situation where lawyers like this would come to, Fordham and Princeton, and we'd have conferences about how to promote the rule of law in China. Most of the people I met with have been subject to these crackdowns. And the problem now is what can be done about it? And the short answer is not much, other than to at least continue to publicize what is going on. What are the legal mechanisms you could use, or at least try to hold China accountable with? Well, a lot of these lawyers are tortured. China's a state party to the Convention Against Torture. China is a member of the Human Rights Council and is up for a universal periodic review. And so that is another forum to keep these, what I'm talking about, before the world's attention. And then finally, one of my favorite things, and this is my final point, is something that a lot of people in the US don't know about but should. It is the UN Basic Principles on the Role of Lawyers. It's almost an international Bill of Rights for lawyers. It is not a treaty. It is a UN General Assembly resolution, essentially. So as such, it's like the Universal Declaration of Human Rights. But even though it's not binding, like the Universal Declaration, it can be very effective in human rights advocacy. I've used it with NGOs in Northern Ireland. In fact, one of my specialties in all those missions I went on is looking at the persecution of lawyers. And this is a mechanism that can be used to help protect lawyers who protect other people with regard to their human rights violations around the world. So it's on that I want to end as something to put on everybody's radar screen with regard to human rights lawyers. So I hope that, given that I was the only speaker, I spoke for the right amount of time, and now I'll take time for questions. I will take us off the share.
Professor Flaherty, that was perfect.
Okay, great. I was
absolutely wonderful presentation. Thank you so much. And yes, you're right. That is, Professor Desierto was not able to come and present. Apparently, she had her life threatened within a short period of time before this, and so therefore she really was in no shape, having suffered that traumatic experience. I don't know much more about it than that. That's all I've been told.
Well, that's
and
awful.
So, very, very difficult for her. But thank you so much for filling in as you did. Excellent job.
Thank
So we do have a few minutes left for questions. So let's see. I don't see any questions popping up here.
I could talk about a couple of things pending a question if.
Well, that would be splendid if you could do that for us. Thanks very much.
Sure. So one thing I didn't talk much about when I was talking about these legal standards was, you know, the mechanisms to enforce them, right? So let's go back to start with Xinjiang, right? And so there I was referring to the Statute of Rome of the ICC. What's the problem? The problem is China's not a state party. And so the jurisdiction of the ICC is territorial and personal, which means that if crimes occur on the territory of a state party, the ICC has potential jurisdiction, or if members of that state party commit those crimes abroad, then the ICC would have jurisdiction. The problem here is China is committing what's going on in Xinjiang is within Chinese sovereign territory. So the ICC is not a real option. It's not unlike the situation in Myanmar, although Myanmar, there's a little bit more of a chance to use the ICC, because since the Rohingya have been forced to the border of Bangladesh, there's an argument that that the human rights violations are also occurring in Bangladesh, which is a state party. And so you might be able to get an ICC investigation by the prosecutor to that extent. So what do you do about Xinjiang? It's really, other forms of advocacy. It's governments and NGOs just holding China's feet to the fire with regard to certainly crimes against humanity and possibly genocide. The problem, of course, even compared to Russia, is, again, China is powerful, so much more powerful. And one thing that Professor Desierto might have talked about was China has been fairly effective using its economic power in the United Nations, both in the General Assembly and in the Human Rights Council, to counter criticism. It's rounded up countries to defend its position in Xinjiang. And that, is problematic, to put it mildly.
Yeah, one of the things I think that Professor Desierto was going to address what she saw as China's widening normative commitments in human rights law, and also its rejection of international accountability.
Yes, absolutely. And, Yeah, and in fact, some scholars have called it, China's trying to redefine human rights with Chinese characteristics, so-called Chinese characteristics. And so what China tries to do with the UN is it does a number of things. First, like many authoritarian states, it just doubles down on statements about sovereignty. But with regard to the issue of human rights itself, it tries to emphasize social and economic rights almost to the exclusion of civil and political rights. And of course, both are by, the US is not the best on social and economic rights, but those attempts are also occurring in UN bodies. The other thing that's happening in UN bodies is China is staffing them. In fact, it is doing a very good job staffing UN bodies throughout the UN organization. And the United States has been missing in action, and not just during the Trump administration. And so China's been filling a void that we have been leaving open. And when it comes to human rights, that's not a good thing.
Yeah, that's absolutely right. The other thing that Professor Desierto was addressed was the emphasis that China has placed on international cooperation in various interstate level and leadership in various international courts and institutions, and of course its continuing refusal to abide by adverse decisions.
Absolutely. Well, the most striking example there is the Philippines brought an action against China in the Permanent Court of Arbitration concerning territorial rights in the South China Sea. Yeah. Because China is trying to argue that it has complete control of the South China Sea, which includes very important shipping ways for the rest of the world. And it also includes claims of a number of other countries around the South China Sea, because the South China Sea is dotted with small islands and rocks that different countries claim. And one of them was the Scarborough Shoals off the Philippines. And the issue wasn't who owned those shoals, but whoever owned those shoals, how far did the exclusive economic zone go? And rights over territorial waters. And in, I think, a 300-page opinion, China lost. So what did China do? It just ignored the opinion. That's that, so.
Well, it looks as if we've come to the end of our allotted time. Let's see, are members of the board present?
Hi, Professor Jimenez. Yes, we're here.
Wonderful, wonderful. Well, Professor Flaherty, I've enjoyed it so much. Thank you so much.
Well, thank you, and thanks, and my best to everyone at Santa Clara and to Professor Desierto.
The next time you're at Santa Clara, I hope you give me a heads up and we can have lunch.
I absolutely. It will be in my date book. Take care.
Thank you.
Thank you. So that concludes our last panel for the day. Once again, thank you so much to Professor Flaherty and Professor Jimenez for an insightful presentation and discussion. Because Professor Desierto unfortunately was not able to join us today, we'd like to give extra thanks to Professor Flaherty for modifying your presentation for this panel. And with that, I'd like to hand it over to Diane for closing remarks.
Thank you, Michelle. So now I will be reading the closing remarks from the current director of the Center of Global Law and Policy and JIL's faculty advisor, Professor Tsai Yang. From Professor Yang. Unfortunately, I was not able to attend this year's symposium. However, I would like to extend my congratulations to Editor-in-Chief Daniel Morizono, the other editors of the journal, and the faculty that have helped the students, Professors Han and Jimenez, for organizing this timely event on China's role in the international legal order. The Center for Global Law and Policy is pleased to support this important event. China's legal positions on intellectual property rights, trade, and human rights have been important for China practitioners for a long time. However, as its economy has continued to grow and as it has extended its influence across the globe, those positions have increasingly affected the rest of the world. Enhancing understanding of the issues has thus become that much more critical for law students, practitioners, and the scholarly community. And so it is with much gratitude that I extend my appreciation to the distinguished speakers, faculty, and student editors for making the symposium a success. Now I'd like to pass it over to our editor-in-chief, Daniel Morizono, to end the JIL Symposium.
Thank you so much, Diane. This concludes our program for the day. On behalf of the Santa Clara Journal of International Law, I want to thank all of our partners who made this event possible, all of our distinguished panelists and moderators, Dean Kaufman for his opening remarks, and our sponsor, the Center for Global Law and Policy at Santa Clara Law. I also want to recognize my colleagues, Diane, Michelle, and Justin, who went above and beyond to plan and execute this program, as well as our entire editorial board and staff for all of their outstanding contributions to the journal over this past academic year. In closing, I want to take a moment to spotlight the important work of the American Bar Association's Rule of Law Initiative. For more than 30 years and more than 100 countries, including China, this organization has provided a range of technical legal assistance services. These include programs to build stronger judicial systems in developing democracies, programs to combat slavery and human trafficking, and programs to assist refugees and internally displaced persons. And the initiative currently is engaged in 2 special response programs, one supporting the resettlement of refugees from Afghanistan, and the other supporting evidence gathering of atrocities and war crimes in Ukraine. Our event today was free to all of our attendees, made possible by the generous support of CGLP, but we nevertheless welcome donations, and this year we thought the Rule of Law Initiative would be a worthy cause to support with any donations received. So when I go off screen, there'll be a slide explaining ways to donate. We'll also drop some links in the chat, and I encourage you to consider supporting this important program advancing the rule of law around the world. As we've explored over the past 3 panels, today China is far more active and influential in reshaping an international legal order long dominated by the West. We hope that engaging discussions such as today's will contribute to an international legal order built upon greater cooperation, stability, and mutual benefit. With that, thank you all very much for joining us. We really enjoyed this program and hope you did as well. Take care.